Afternoon and welcome everyone to Reimagining Bail in Virginia 2022 and beyond. First, thank you so much to the Virginia Community Criminal Justice Association, the VCCJA, for planning this event, getting us all together to have what I hope will be a great discussion today. My name is Bryan Kennedy. I'm the policy director with Justice Forward Virginia. I'm also a public defender, and I'm going to be your moderator. Before we jump in, I want to talk about a few housekeeping. Thanks for everyone. First, this is webinar format, as I'm sure after 2 years you were all used to. But if not, that means your video and audio aren't on, so you don't have to worry about that. No one can see what you're doing at your desk at work. So if you want to interact with anyone, however, the best way to do that is through the question and answer function. At the bottom of your screen in Zoom, it says Q&A. If you open that up, that's going to be your way to get questions to the panelists as we go through our presentations today. There will be some time built into each of the presentations for questions, so please put them in. We do want to make sure if we have time, we get those questions answered and we have time to look at them to see what will be the most interesting question for that time and what's going to be presentations with a lot of content. We're also going to take breaks. We're going to be here for a long time. We're scheduled to go till 5. So more or less at the top of each hour, but really between different segments of the presentation, we'll be taking 5-minute breaks. I'll tell you when those start. I'll tell you when we're going to be back and we'll pick up. Also, this webinar is going to be recorded. So everyone who registered in a few days, once it gets cleaned up, will be getting a link to the recording of this video and also the slides used by the presenters. So don't worry about taking copious notes. You'll have a lot of the content there if you need it later on. So over the past few years in Virginia, we've made some relatively modest changes to our pretrial system, but obviously there's still a lot to consider. Anytime we're dealing with people's liberty, especially liberty before conviction for a crime, all actors in the system should be asking, what are we doing? Are we doing the right thing? Are we doing something that makes sense? And are we doing things that comport with the constitutional safeguards and ideals that we have in a criminal legal system? And today we're really lucky to be joined by 2 leading national experts on bail and pretrial issues to help us take a look at those issues, both generally and here in Virginia. First, I'd like to introduce Michael Jones. Michael is the president of Pinnacle Justice Consulting. He's been doing that since 2017, although he has about 20 years in various capacities of working in the pretrial and criminal legal system. In his current capacity, they provide training and assistance to states and stakeholders that are looking to implement research-based criminal justice policies and initiatives. We also have with us Tim Schnacke. Tim is a criminal justice system analyst. He's been doing that for over 30 years. He's currently the executive director for legal and evidence-based practices. They do research and provide assistance to states and localities seeking to make changes to their pretrial systems. Without any further ado, Tim, take it away.
Caught me off guard. All right, let me get my screen going here. Can you see that and can you hear me? Mike's nodding, that's good. Thank you, Brian, and thank you also to Ken Rose and Steve Austin and Pat Smith, who are sort of the 3 people I constantly talk to in Virginia for asking us to come. And thank you all for coming. I think it's going to be a fruitful day. First things first, I am not wearing a hat because I think I'm cool. I'm wearing a hat because I had a couple of guys operate on my head. And believe me, if I took the hat off, you would say, put it back on. There's a pretty ugly bandage on there. So that's the hat. I tried to pick one that didn't make anybody mad living in Virginia. This is a college in, in Great Britain, for goodness sakes. Also, I was asked to talk about this, Reimagining Bail in Virginia, and this is a really great title. And but I'm always thinking, when people give me titles to talk about, I'm always thinking about what would I have in the way of a subtitle if I were going to do something. And I came up with, a subtitle like you would with a novel or a book. And I wanted to say this: the Reimagining Bail, to me, is actually pretty easy if you know all the right stuff. And if you know all the right stuff, if Virginia knows all the right stuff, I really believe, having looked into it pretty deeply, that Virginia can actually lead America in 22 and beyond in the field of pretrial justice. Here's the way I'm going to show this today. We've done bail in the states, each of the states a certain way since about 1830, which is typically we look at your charge, we throw down some money, and then we wait around to see what happens. And what I've seen over the past 15 years I've been doing this is I've seen successful pretrial changes being made on a sort of a global scale, but they always have three phases that are the same everywhere I go. First, I see a phase of education. And it's not just general education, but it's education in something I call the fundamentals of bail. And the fundamentals of bail tell you certain things. They tell you, for instance, that bail reform is actually inevitable when there's certain markers. It also tells you that money as a detention mechanism is likely going away in America. So the education in the fundamentals of bail is really important. Secondly, we tend to see pressure everywhere we go, and it comes in different forms. And so we're going to talk about that today too. And if you have pressure, what usually it means is that the state then starts to look at their model of how they do intentional release and detention with no or less money. Now, the key to this is you want to be able to do these sort of in order. You don't want to come along and have a lot of pressure put on you, and suddenly you're looking at your model and you have no education, you don't know what you're doing when it comes to creating a new model. So the key is to try to understand all of these, and that's what we're going to try to do today. So I'm going to focus on certain parts of the fundamentals of bail that I think you need to know. And Mike's going to do a little bit of that too with pretrial research, some of the pressure that we've seen across the country, and also then what that means in the way of changing or adapting your model. Now, when I talk about, first of all, why should I watch and not play cards? I think it's important because I think everybody right now in America is being asked to assess their current release and detain model and decide whether it needs changing or not. You're going to get pressure. You're either going to have pressure put it on yourself by saying, hey, we just want to do things a different way. We want to do things more intentionally, whatever. Or you could be sued a number of different ways. So I think it's helpful to watch because I think this will help you understand how to assess your model and actually how to make those changes if you do want to change them. I was at a panel very recently in another state, and somebody actually asked the question, he said, do we have the answers right now, or are we just sort of waiting to figure stuff out? And that's why states are being so slow. And everybody on the panel seemed to agree. We do have the answers to all the questions that are necessary to make meaningful change in this generation of bail reform. I could take you back to the 60s or in the 70s and 80s in earlier generations of bail reform and show you documents where people said, we just don't know the answer to blank, and they left it alone. But in this generation, I think we have the answers to put lots of these nagging questions to bed for a long, long time. So when I'm talking about the fundamentals today, I'm going to talk about what I call the story of bail. And this is a story of bail in America, but it comes from England. And so it's going to apply sort of to broadly all of the United States. So you're going to see some things. Some of you have even seen some of this before, and you're going to say, oh yeah, I've seen this. But then we're going to turn the corner eventually, and we're going to talk specifically about Virginia and how you fit in. And I think it's important because you have specific issues that lots of states don't have. For instance, you don't have a constitutional right to bail in your constitution. Your bail, no bail stuff is done in your statute. Every hour, we're going to take a little 5-minute break at the top of the hour. I'll tell you when. And then because it's a story, I think it's important that you write your questions down in the question and answer column, but I don't think we're going to get to them during the presentation. I'm going to leave time at the end to talk about questions, simply because a lot of times when I tell this story, people will have a question and it gets solved by the story as it goes on. So first, before I start, there's certain words I use and I want you to know what they mean. If I say the word bail, I do not want you to think money. I want you to think release. If I point to my big bail sign, you think release. Bail is a process of conditional release. No bail is a process of detention. I think that'll be easy today because unlike a lot of states, you all define bail as a process of release in your statute. So that's really helpful. If I say something is moneyless, I don't want you to think that that means that there's no money whatsoever involved in the bail process. None exists at all. What I mean is that money can't keep you in jail. A moneyless system to me means that even if you have money, it can't keep someone in jail. And if I talk about a model, I want you to not think necessarily of one single precious model that we all point to and say, this is the way we should do it. This is the ultimate model. I consider a model to be any release detain scheme with all of its details. So your constitution, your statute, your court rules, your case opinions, how you use money is your model. You had a certain model 10 years ago. Your model today is different than the model you had 10 years ago. So always be thinking in terms of your model. Every state has a model, the federal system has a model, and now there are hypothetical models, and we'll talk about those. The one thing I like about talking about the fundamentals of bail is because it immediately allows me to talk about this phrase. This phrase, by the way, is code for bail. You know, when you're talking about this, legal and evidence-based practices, you know you're in the field of pretrial. And I like this. This was actually coined by a very important bail researcher. Her name is Marie Van Nostrand. And she was looking up some stuff a long time ago, back in 2007. She was trying to figure out whether you could take post-conviction research and use it in the pretrial phase of the case. And she wrote a paper for NIC in about 2007 and said, well, you kind of can, but you really got to watch out. And so even though everybody else wants to follow what they call evidence-based practices, in the field of pretrial, we really ought to follow what she called legal and evidence-based practices. And eventually I talked to her and said, man, this is phenomenal. I love this phrase because it sums up every single thing that I do. When I look at anything having to do with bail or no bail, I want to know if it's lawful and I want to know if it works. And then realize these things are interconnected. Sometimes something can work really, really well, but the law is going to say you can't use it because it's unfair. Other times, if it doesn't work, it might mean that the law says you can't use it because it's irrational to use. This phrase was so important to me and summed up everything I do that I actually call my nonprofit, the Center for Legal and Evidence-Based Practices. I told Marie once I owe her $1 every time I use the term, and so by now I owe her a lot of money. People say, I want to learn evidence, legal and evidence-based practices. What do I need to know to do it? And why do I need to know it? And I say, well, you need to know the fundamentals of bail. If you know the fundamentals of bail, you can do anything. I mean, all the way from advising a judge, recommending some condition of release, all the way up to changing a constitution or revamping your entire statute. They help with everything. The good news is you don't have to write them down. I already did. In 2014, I wrote 2 papers. The first paper is called Fundamentals of Bail, and it listed 6 big subject matter areas that are the fundamentals. And in the second paper, I said, I'm going to write another paper that says, if you follow the fundamentals of bail, well, how would you set bail? And the second one was sort of written for judges for the most part. And it said, this is the way you'd set bail. If you follow the fundamentals, it's going to be an intentional in or out decision, immediately effectuated with nothing standing in the way of the in or the out. And then I had to drop a footnote in each paper. And in the footnote, I said, you know what? You're probably going to have to change all your laws to do that intentional release detain thing. Our laws right now are not designed to do it that way. So what are the fundamentals? Well, here they are. Why change it all, right? What's the problem? History of bail, legal foundations. I'm going to give you just enough of those today so that you'll think they're important. Pretrial research is a fundamental that Mike's going to take on in the 3rd hour. I'm not going to talk about national standards, though we have 2 sets that are helpful. The American Bar Association and the National Association of Pretrial Services Agencies both have standards, and they're very helpful to know. And also terms and phrases at bail are important to know, the legal and historical definitions and things. And I'm not going to talk about them primarily because Virginia is a state that understands that bail is not money, that bail is a process of conditional release. The big issue when you study the fundamentals of bail, of course, is money. And by money, I don't mean just any kind of money in the bail system. I mean one particular form of money, which is called the secured financial condition. A secured financial condition means you have to pay something in order to get out of jail. You may have to pay cash, it may be property, maybe you have to pay a fee to a bail bondsman, maybe it's a 10% scheme in some state. These are all secured forms of bond. You have to put something down in order to get out of jail. And secured financial conditions cause really big problems. It's our big issue. In fact, you can see the problem simply by holding them up to the other fundamentals. Historically, we didn't really start using secured financial conditions until about 1900. And then ever since then, they've been flawed and we've had problems. Money is the thing that's at the root of all these lawsuits you keep hearing about. We'll talk about a couple of those. The research shows it doesn't even work, and the standards say you shouldn't use them. In fact, they cause problems at both ends of the spectrum. Now, I didn't make this term up. This phrase came from the New Jersey Supreme Court. Chief Justice Rabner put together a group to study bail and no bail, and he came out with a report, and on the front page, it says, you know what, we're looking at these secured financial conditions, and they cause problems at both ends of the spectrum. And the first end is illustrated by this guy you see on your screen. His name is Leslie Chu. He's what you would call today a low-risk defendant. He didn't really have a criminal history. He had a job. He had a car. Now, he was poor. He lived in his car. And he was out in West Texas. He was working in the oil fields out there. And one night it got really cold. And so he went to a store and he decided to shoplift a blanket. And he got caught immediately. And I don't know if they took him to a police station or if he saw a judge, but either way, his amount of money to get out of jail, his secured financial condition, was $3,500. Well, he didn't have that. And he didn't have $350, or I suppose he would have bought a blanket. So he stayed in jail for about 8 months. We have his picture because NPR did a story on him. I put it up here because this happens all the time in America. There are people in jail that cannot get out because of money. There's a group in America that says this is a myth, and they say that because they make money on this whole process. But that's not the only thing that happens with secured financial conditions. Maurice Clemens assaulted a police officer. He went before the judge, and the judge said, you know, this is pretty serious. I'm going to set your financial condition of bond at $30,000. And but Maurice, that wasn't such a big deal. He had money. He knew a bondsman. He got out of jail. Within a week, he arrested him again. This time they accused him of trying to rape 2 small girls. And the people in the system said, holy smokes, we need to assess this guy. We need to question him. And they went back to the judge and they said, Your Honor, this guy's highly likely to reoffend. He's incredibly dangerous. We think he's going crazy. He's talking to himself. Family's all worried. And right at that moment, the judge did what I suppose judges have done in America for a long, long time, maybe since the mid-1800s, and maybe thought to himself, well, you know, $30,000, that didn't seem to do the trick. I'll set your financial condition at $180,000. But Maurice had money. He knew a bondsman. Bondsman cut him a deal on the front end, and he got out. And within a week, he went up to Parkland, Washington, walked into a cafe and shot and killed these 4 officers. So you see, we have problems with release, bail, and detention, no bail, and they're based primarily on how we deal with these things called secured financial conditions. But money is everywhere in bail. It's amazing how deeply ingrained it is. We have states that define bail as money, and they'll actually say that their right to bail must have something to do with money. The question is, does it have to be? And the answer is no. And the reason why I know the answer is no is because I understand the fundamental of bail called the history of bail. Now, the thing I like about the history of bail as a fundamental is that it helps you understand bail reform. Because if you understand bail reform, then you know how we get into eras of bail reform. We're in one now. You'll know how to get out of them, and you'll know how to avoid them in the future. So to understand bail reform, all I'm going to do is take you back to 1274 in England. Now that's appropriate because back then we got all of our bail laws, we got all of our bail laws from England. And back in England in 1274, you were either bailable or you were unbailable based on custom. So it was like our common law. And this was the king, Edward I. You may recognize him. He was in a certain movie with Mel Gibson. Well, Edward had heard rumors that bail was being done improperly in his land. And so he sent out a bunch of inquisitors and he said, go out and find out what's happening, come back and report to me. And they came back and said, Your Highness, things are bad out there. And he said, what's going on? And they said, well, you know, the sheriffs are your bail setters, right? Yeah, I knew that. Well, there's people showing up on the sheriff's doorstep and they're customarily bailable. But the sheriffs are looking at them and saying, I know you're customarily bailable, but I'm not going to let you out of jail unless you give me some money. And other people are showing up on the sheriff's doorstep and they're customarily unbailable. And the sheriffs are looking at them and saying, you know, I know you're customarily unbailable, but I'll let you out if you give me some money. Well, this made everybody mad. The king was, I like to say, royally ticked. Parliament was upset, so they passed the Statute of Westminster in 1275. And the Statute of Westminster said, from now on, there is no more custom. You're either bailable or you're unbailable based on the statute. And sheriff, if they're bailable, you have to release them. Bail means release. And if they're unbailable, sheriff, you have to detain them. No bail means detention. And you can't take any money. And if you screw this up, sheriff, we'll put you in jail. The Statute of Westminster created the first legislatively articulated bail, no bail dichotomy. You're either bailable or it's no bail. Now, bail, no bail is really, really important because everywhere I go in America today, I find it. Usually all I have to do is open up someone's constitution, state constitution, I find it. Everybody's got a right to bail except no bail. In Virginia, I just have to open up your statute. Bail, no bail. But that's not the thing that helps you understand bail reform. The thing that helps you understand bail reform is this other notion that comes along with it, that bail was always supposed to lead to release. Just like no bail was kind of supposed to lead to detention. In fact, this rule is such a big rule that anytime anything interferes with bail as release or no bail as detention, or put another way, if you ever see the wrong people in or out of jail, bail reform always happens. Now, it happens every so often with no bail. Every so often we look at the no bail bucket and we think, well, these people should be in there, or maybe we should add this process or that process to no bail. But mostly it happens over here with bail. So much so that as another rule of thumb, historically speaking, going all the way back into England to America, if you see a bailable defendants in jail, almost guarantee you're going to see bail reform. And we've had some big reforms due to bailable defendants being in jail. We have habeas corpus because of that. We have the rule that says prosecutors have to charge you because bailable defendants were in jail. We have the excessive bail clause because of that. So remember this rule of thumb because it comes up later. Now, we did no bail back then the same way as we did no bail today. We lock you up. Now, we think we do it better today, but same thing. But we did bail completely differently back then. Back then, we used what's called the personal surety system. What's that? Well, that had three elements. First, the sheriff would have to go find a person, or maybe three people. You know, the guy looks dicey, I'll put three sureties on him. That person or persons had to secondly agree to take responsibility over the defendant or the accused. And third, they weren't allowed to make any money. You couldn't profit from this. This was considered to be too big of a duty, too important. In fact, if you shelled out any money at all as a surety, you couldn't even be paid back. You couldn't do what we call indemnify. Money simply wasn't allowed in the process, except in this little thing that we call today your financial condition of bond. Now, that had always been there. Something like that has always been a part of this process going back all the way to 400 AD. There's always been something that hangs over the head of the accused to get them to come back if they're let loose in the community. Before money, it was property. Before property, it was people. After money, it'll probably be something like the threat of an additional charge. But get this, for hundreds and hundreds and hundreds of years, all through the history of England, all through the history of America, up until the 1800s, this financial condition had only ever been what we call today an unsecured financial condition. What's that mean? Well, that means you don't have to put anything down to get out of jail. You merely make promises to pay, or pledges, they would say back then. Either your surety would make a pledge, or you would, or maybe both of you. And that's how we could make sure that all bailable defendants got out of jail, because we had lots of personal sureties and all they made were promises to pay in case of failure. And when we moved it to America, we said, this is fantastic. We like all of it. Bail's going to be released, no bail's detention. We're going to use personal sureties, unsecured bonds, and we're going to put it in our laws. And we're America, by the way. And we're really big on liberty and freedom. So we're going to do three things different than England. And the first thing we did was we said, well, we're going to enlarge the bail part. So gradually over time, the right to bail became bigger and bigger. No bail became smaller and smaller. And then we said, now, when it comes to bail, if you commit any of the charges that we claim are bailable charges, you're going to know that you're going to be released. Bail is going to equal release. Now, wait a second. Tim, I thought you said that the Statute of Westminster did that. I thought the Statute of Westminster said bail is released. It did. It's just that after people were working that statute for a few hundred years in England, some discretion started to seep back in. And the discretion came in this form that every so often, not very often, but every so often, a judge could actually look at you and decide if you were bailable or not, based on factors beyond what you were charged with. Now, it's easy to have a rule that says you got to release all bailable defendants if you get to decide if they're bailable or not, right? That discretion is what America did not want. They said, we want to go back to the way it was. We're going to call it bright line bailability. If you are charged for a bailable offense, you will be released. If you're charged with the offense over here and no bail, you might be detained. And the third thing we did was we said, just because you're in the no bail bucket, that shouldn't necessarily mean that you're automatically detained. So we added a thing that I call the further limiting process. What's that? Well, that just means that the judge has to decide, make another finding to keep you detained once you're in this bucket. And the very first one you ever saw was called proof evident presumption great. So the very first bail clause you might have seen was everybody has a right to bail except capital offenses, but only when the proof is evident and the presumption great. If it's not evident and not great, even these people can get out. So in America, everybody is eligible for release. Nobody is automatically detained. That meant when you look at these bail, no bail clauses, either in constitutions or statutes, what they were was a state's articulation of intentional release detain. It was the way we did bail meant that if you were bailable, you were going to be released. And the no bail clause, whether it's in the Constitution or your statute, has always been made up of two things. A detention eligibility net, meaning if you're in this net, you're eligible to be detained with no bail, and a further limiting process. We just always had them. And the whole thing worked really, really well in America up until the 1800s. The problem is in the 1800s, we started running out of those personal sureties. So what's that do? That causes bailable defendants to be in jail, right? And remember I said a rule of thumb says if bailable defendants are in jail, we see bail reform. So we knew we had to do something. Now it happened in England and America at the same time. So England, they decided, what they did is they said, let's pass a law that says judges can release people with no sureties, just sort of on their own promise. But in America, we didn't want to do that. America said instead, why don't we chip away at those rules that say you can't profit from bail? Let's chip away at those rules that say you can't be indemnified at bail. So what we did in America, different than everybody else, is we said, let's move to what we call the commercial sured system. Now realize we did this to help get bailable defendants out of jail. But we also did something at the same time that I don't think we saw coming, because when we moved to this new model, remember the financial condition of bond, that had for centuries and centuries and centuries been an unsecured financial condition of bond. Under this new model, it was mostly going to be a secured financial condition. Well, what's that do? That means people have to pay. There's fees attached to having commercial sureties. What's that do? That causes problems with bailers' release. Bailable defendants, they can't find personal sureties. They can't afford the fees. In fact, under this new model, a bail bondsman could walk right past you and not help you at all for no reason. So what do? Well, we have bail reform. We have what's been called by historians and legal scholars the first generation of bail reform in America. Now, why don't I call that other thing bail reform? How come I don't call moving from personal sureties to commercial sureties bail reform? We did it to help people get out of jail. But nobody does. No historian, no legal scholar does. I'm convinced it's because it didn't work. And in fact, it made it worse. All you have to do is look at the dates. We had our first commercial surety in about 1900. By 1920s, we start to see papers by really smart people like Felix Frankfurter, Roscoe Pound, saying, oops, we've made a big mistake. And so we spent decades once again trying to figure out how to get bailable defendants out of jail. Now, we had a second generation of bail reform, and this was interesting because there were people getting out on bail and they would commit crimes. And a group of folks said, well, we don't want them out on bail. We want them in the no bail bucket. And a different group of folks said, well, how are you going to do that? And the first group said, well, we're going to make a prediction that they're going to commit a crime. And then based on that, we'll put them in the bucket. And the second group said, that sounds completely un-American to me. And by the way, public safety, that's not even a valid purpose for limiting pretrial freedom. The only thing you can consider at bail is flight or court appearance. So these were all really important questions, and they were all solved in the second generation of bail reform in America. Turns out the US Supreme Court has said, you can do all these things. You can enlarge your no bail bucket. You can put people in there based on a prediction of something they may or may not do in the future. And you can base it on public safety in addition to flight. Most people look at this generation of reform mostly focused on detention, but realize it also dealt with release. And in fact, in a couple of papers I've written, I talk about this as being the big fix. The result of the second generation of reform in the federal system became the big fix. Well, how did they fix everything? Well, they fixed release by taking money out as a detention mechanism. They simply removed it. You can't stay in jail with money anymore in the federal system. And then they turned around and said, well, if you can't have detention that way, then we're going to have to set up an intentional release detain scheme. What's it made up of? Same things it's always made up of: detention eligibility net and a further limiting process. Now, don't get me wrong. Don't go out tomorrow and say, I want to use the federal model because Tim said it fixed everything. Only broadly, take it for what it did broadly and not the details. The federal model actually has led, because of certain structural difficulties in it, has led to over-detention like you wouldn't believe. So just remember what it did. Took out money as a detention mechanism, created intentional release detain. What about the states? Well, they didn't do the big fix. In fact, they cherry-picked from the generations of bail reform. These were mostly done in the federal system, and the state would look and say, well, we like that, but we don't like this. So they were still doing bail the same way. After 180 years, they look at your charge, throw down some money, wait around to see what happens. That leaves lots of bailable defendants in jail. And so bail reform was stalled in the states. So why were they stalled? What is happening now that's pushing them out of this stall? Well, the answer to these questions is found in another fundamental of bail called the legal foundations. Now I'm going to talk about those very quickly. The legal foundations, first of all, I got to tell you three quick things about the law at bail. First is that the history and the law are totally intertwined. So if you think you know the law already, learn the history because it'll help you understand the law, and vice versa. This just goes back to what I said about the fundamentals. You need to know each one in equal measure. Secondly is, when it comes to the law, you're going to do bail based on what I call your mix of sources of law. The way you do bail in Virginia is going to be based on all these things. Now, why this is important is because lots of people have called me on the phone and they say, please come to our state. Tell us what California did. Tell us what Illinois just did. Tell us what New Mexico did, New Jersey did. And I'll say, I'll tell them what they did, but there's a real good chance you can't do that because your mix is different than their mix. The key to this slide is that you have to know your own mix, but it's helpful for you to know other states' mixes so you know what you can and cannot do. And finally, the law at bail is incredibly sparse. I mean, think about it. When it comes to like sentencing, how many sentencing opinions in the US Supreme Court do we have? I'm thinking about 6 billion and 2. But at bail, we only have 2 cases in the US Supreme Court. Well, now you would think if we only had 2 cases, then they must be really important, right? So important that perhaps we'd open them up and quote from them at parties, and maybe we'd hang them on our cubicle wall. But in fact, we often ignore these cases. And I'll give you 2 examples. The first deals with individualization. It's a rhetorical question. Who here believes that criminal justice should be non-arbitrary? Yeah, we all do. How do you make things non-arbitrary? Well, one way is to set up standards. And if you have standards and they're lawful and objective standards, then you can plug people into the standards, and then the treatment that they get is okay. So the best example of this is the death penalty in criminal justice. The Supreme Court says that can never be arbitrary, and therefore it has lots and lots of cases looking at the state standards for implementing the death penalty. Well, guess what? Bail is supposed to be the same way. In 1951, in a case called Schnacke versus Boyle, the Supreme Court said, because the function of bail is limited, you have to have standards, and they have to be applied to each defendant in each case. And when they said that, every single state knew what they were talking about. And so every state enacted into their laws what I call the factors. You have them in your law too. I've seen them. The factors will say something like, well, in every single case, the judge shall consider the following factors: criminal history, community ties. You've seen those. We had 16 factors in Colorado. It said in every single case, the judge shall consider the following 16 factors. But guess how we did bail in Colorado for decades? We used these things called bail schedules. It was a piece of paper, it had a charge and money. And once you were given that money, it just kind of followed you through the system. What about the factors? We ignored those. We ignored the factors. What about Schnacke versus Boyle? I don't know that we even knew that Schnacke versus Boyle, existed when we were talking about this. What about the bigger issue of making sure that criminal justice is not arbitrary? Yeah, that's a problem. This still happens across the country. The good news is in Colorado, the more we talked about this, the more we started to realize, oh, I see why bail schedules might be a problem. But this happens actually more frequently. Remember I said in the second generation of bail reform, the Supreme Court said, okay, you can enlarge your no bail bucket, you could put people in there based on prediction of something they may or may not do in the future, and you can base it on public safety as well as flight. Well, because that was practically un-American, the court said, this is kind of dicey stuff. You're talking about detaining people based on prediction. Therefore, you've got to do two things if you're going to do this whole on-purpose detention based on prediction. The first thing it's got to be is really, really limited. What does it say? Well, it says carefully limited. And you have to read the case to know what carefully limited is. It's like a term of art. It has elements to it. And you can read other cases that talk about what makes a detention statute carefully limited. From a distance, though, it just means you're just not supposed to do it very often. Most people are supposed to be released. Fewer people are supposed to be detained. The other thing they said is it's also got to be really, really fair. I mean, you're detaining people based on prediction. And so when they looked at the federal statute, the Supreme Court said, well, we like this. What they do is like a full-blown adversarial hearing. They have lawyers present. They allow evidence. They allow cross-examine of witnesses. It's not easy to detain someone on purpose using prediction. That's because the Supreme Court said it shouldn't be. But guess what? I can walk into a courthouse any day of the week in America and watch somebody get detained in about 8 seconds, just long enough to rattle off a line or two and then set some amount of money. And that person is in there with no due process, no detention hearing, none of the stuff that case Salerno from 1987 says we have. Now, right about this time, if I were there, I would start to see people scratching their heads. And it's because this always comes up. People say, no, wait a second, Tim, this is getting too weird for me. You said that the history shows that anytime there's bailable defendants in jail, we see bail reform happen. I go, yeah, that's true. And now you're starting to show us that if there's these bailable defendants in jail, and it looks like maybe they're in there unlawfully. I don't get it. This thing, it makes no sense to me. We've had bailable defendants in jail for as long as I was alive. When I was a kid, I would sit on my grandfather's knee and he would talk about how he sat on his grandfather's knee and they talked about how many bailable defendants were in jail. And if that was wrong, if any of these things were true, then surely by now, the American justice system would have figured it out and made sure that it was okay, right? Well, the only way to understand why we have so many bailable defendants in jail and why we haven't fixed it yet is to understand this last thing. Now, this is the last thing I'm going to talk about that takes you back into history. I call it the excessive bail loophole. To understand the excessive bail loophole, all we have to do is go back one more time into the 1800s. Remember, I said judges ran out of personal sureties. Remember, I said that causes bailable defendants in jail. We needed to do something. And I said what we eventually did in America was we moved to the commercial surety system. Well, guess what? That took about 70 years. So in the meantime, judges tried other things. And one of the first things they tried was they said, why don't we see if these defendants can pay that financial condition that we have up front? Now, that was the first use of a secured bond, wasn't it? But we didn't have those words. We didn't have secured and unsecured. So they called it self-pay. Let's see if the defendant can self-pay. And they couldn't. And so you started to see all these cases coming up. And they were all the same. The defendants would say, this is unconstitutional. I have a right to bail I can afford. How can it possibly motivate me if I can't even get out of jail? And right at that moment in history, the excessive bail clause of the US Constitution or of any state could have swooped in and said, you're right, it's unconstitutional if it's unaffordable. Had that happened, I wouldn't be here today because every state would have created bail laws around that notion that money can't keep you in. But that's not what happened, was it? No, instead, in every single case, every single judge ruled that it's not necessarily unconstitutional. You've heard it said this way: you don't have a right to bail that you can make. Well, what makes it a loophole? What makes it a loophole is that these cases that say you don't have a right to bail you can make only applies to intentional detention. What's that? Well, the best way to describe it is to tell you how it happens. Here's a person, a judge is setting bail. He knows what bail is. He says bail is a process of conditional release. So he knows what to do. I'm going to sign a release order. I'm going to set some conditions. 1, you're going to come back to court. 2, you're going to check in with pretrial services. 3, you're going to pay $6 million in cash. And then maybe he says this: I'm really keen on you getting out of jail. I want you to have your liberty prior to trial. It's just that the $6 million gives me reasonable assurance that you're going to come back. Without the $6 million, I don't have this reasonable assurance. When that happens, these excessive bail loophole cases come in and they say, yeah, that's okay. And the fact that the guy's detained is just an unfortunate byproduct of a conditional release system. But these cases don't apply to intentional detention. How does that work? A couple different ways. Judge can look at you and say, I see you're bailable, but I'm not going to set your bail. Reversed, every single time reversed. In fact, this is such a foundational case that usually you have to go back to the 1800s to find it in any state. But it's the same everywhere you go. Okay, judge learns his lesson. I'll do it. I'll set your bail. Here's the release order. I'm signing that. Come back to court, check in with pretrial, pay $6 million in cash. And then he says this on the record: I'm setting the $6 million because I don't want you to get out of jail. I hope you can't afford it. I'm worried about public safety. I'm worried you're not going to come back. I hope this is an amount that keeps you in. Whenever that happens, it's rare, but whenever it happens, reversed. And every single time that these cases get reversed and they go up on appeal and there's an opinion, the appellate courts always say the same 3 things. They'll say, you can't keep a bailable defendant in jail on purpose using money, because if you can do that, then you're doing something dishonestly under bail that maybe you could do honestly under no bail. Or they'll say this: you can't keep a bailable defendant in jail on purpose using money, because if you can do that, you're adding an exception to our bail clause. You know, we have this thing that says everybody gets admitted to bail except. You're adding an exception. You can't do that. You're adding to the law. Or they'll say this: you can't keep a bailable defendant in jail on purpose using money, because if you can do that, then you could just ignore this whole thing. Why even care about any of this if you can keep anybody you want in on purpose using money? So you see the loophole. The loophole allows judges to detain anyone they want as long as they make the right record. Now, that's been going on since the 1800s, and that has allowed every single state to ignore its articulation of intentional release detain. Now, it's also masked the need for reform, because people look around and they say normally a marker of bail reform is having bailable defendants in jail. But these cases seem to make it seem okay that all these bailable defendants are in jail. Because after all, they had a court case that said it was all right. Probably more importantly, when we moved the entire bail process from England to America, the one thing we wanted to take out of it was discretion. Remember, some discretion had creeped in and we took it out. These cases provide 100% discretion to detain anybody. This is going to make it difficult to do bail reform in America simply because in most states, we've gotten used to detaining anyone we want. And moving away from that is really, really hard for the people with the discretion. So let's really review very quickly what we've learned about federal and state bail models, the release detain systems in the federal and the state. Remember I said in the federal system, after all those hundreds of years or 150 years or so, they fixed unintentional detention by taking money out as a detention mechanism. Those loophole cases just don't exist in the federal system anymore. They don't come up. And then they turned around and fixed intentional detention. How? By creating a limited charge-based detention eligibility net and a further limiting process for both flight and public safety. What did the states do? Well, every state had bail, no bail somewhere in their laws, either in the Constitution or the statute, but every state also had money. So you could ignore this, and most states did. And every single case was decided under the excessive bail clause of the 8th Amendment. If you brought a bail case, it was always decided under the 8th Amendment. What's that mean? Well, that means the loophole cases kick in and people are in jail with money. So far what we've seen is that the history and the law are incredibly important to understanding models, because you can see what the federal model is, and you can also see what sort of the state models are. And of course, another fundamental that we're going to talk about today too is pretrial research, especially the risk research. So the fundamentals are very important to sort of getting a grip on what it is out there that we're looking at. But from this little snippet of history and law, just look what you've seen. The history says if anything interferes with bail is release or no bail is detention, i.e. if you see the wrong people in or out of jail, we see bail reform. It becomes inevitable. It's always happened. Secured bonds interfere with both release and detention. We saw those from those two pictures of those two gentlemen, one at both ends of the spectrum. The first bail, no bail dichotomy in 1275 was a moneyless, intentional release detain system. The first American bail laws were moneyless, intentional release detain system. Money comes creeping in the 1800s, causes bailable defendants to be in jail, which of course is supposed to lead to bail reform. After a long, long time, the federal system fixed it by eliminating money as a detention mechanism and creating intentional release detain. But reform was stalled in the states until now, the third generation of bail reform. Now, before we take a break, and then I'll continue this story of bail of why reform is finally hitting the states, I want to talk about this really quick because it takes these two fundamentals, the law and the history, and tells you what you learn from both of them together combined. One important thing, by the way, you learn is what bail is. When I say bail is a process of conditional release, what the definition of bail is, it comes from the history and the law. But it also tells you this. Back to what we first talked about, legal and evidence-based decision-making. When you're doing sort of evidence-based decision-making, what you're really trying to do is just use what works to achieve your goals. So you're always asking this question, what works to do blank? Well, back when the health field sort of jump-started this notion, they were pretty clear on their goals. They knew what to do. They wanted to keep people out of hospitals and reduce disease and all these different things. But when I started writing about bail 15 years ago, nobody knew what they were doing. We didn't have anybody articulating what our goals were. What are we trying to do when it comes to bail? And so I came up with a way to remember it. And this is it. When we are trying to do bail or release, we're trying to do three things at once. Trying to maximize release, maximize court appearance, maximize public safety. These are things you glean from all the law and the research and the history. Now, I use 3 M's because I want this to sort of burn into your brain. This is very important. I have a picture of 3 M&Ms, which is rare because, as we all know, they travel in pairs. This is our goals for bail or release. Now, wait a second, Tim, you talk about no bail all the time too. What are the goals of both bail and no bail together? Well, I might change the first M, and I might say, well, what we're trying to do for bail and no bail is we're trying to put people in the right place. We're trying to maximize the appropriate placement of defendants pretrial. They're either in or they're out. And then these other 2 things. But this happens to be one of those cases where the law comes flying in and says, yeah, but mostly you're going to deal with release. In America, you're supposed to release way more people than you detain. So mostly you're dealing with this: maximizing release, court appearance, and public safety. Now, what do you see when you look at these goals? Right off the bat, you realize, well, these are competing purposes, aren't they? Wouldn't it be great if I didn't have to release anybody? I could have phenomenal court appearance rates and phenomenal public safety rates. Now we have to balance these things. Well, the fact that it's a balance tells me 2 things. One is bail is inherently a judicial function. Now, I believe everybody should do the balance. If you're a prosecutor, defense attorney, pretrial person, anybody, you should always be sort of thinking about all 3 M's anytime you're thinking about anything in the pretrial phase of the case. But judges are required to do the balance. They are held up to error on appeal for not doing the balance. So bail is inherently a judicial function. If you think of maximizing release being the defendant's liberty interest, court appearance and public safety being the government's interests, then you can see why this is so important that judges be involved. That's why I am constantly amazed when I would read that judges simply weren't involved in the first 2 generations of bail reform in America. They are involved in this generation, and rightly so. The second thing this tells me is that you can never think of just one of these at the expense of the others. You always have to think of all 3. But this happens all the time. Somebody might come to you and say, well, next year we're going to introduce the 2022 Maximized Public Safety Bail Bill of Virginia. And you might say to yourself, wow, that's one of the M's. It's fantastic. That's something we care about. But you wouldn't be done, would you? You want to know how that bail bill affects court appearance and affects release. Maybe it does nothing to court appearance. Maybe it really screws up release. You want to know those things. Research, same thing. If somebody comes to you with research showing only one of these M's, it's not as good as research that shows all 3 of the M's. And that's where money bonds tend to fail. Even if you thought, for instance, that money helped with court appearance, they do nothing for public safety and they really screw up release. So it's one of these really great rules of thumb you can use for all research where you just sort of do a quick balance. Now with that, this is going to be our first 5-minute break at the top of the hour. And when we come back, I'm going to take over and finish up by going through how the states are changing based on the pressure and then the kind of models that we're changing to. And then I'm going to talk about Virginia in particular and your exact model that you have now. So Brian's there, we can set the clock.
Yep. Everyone, let's come back at 2:59. So right before 3 o'clock, 2:59, we'll come back for part 2. Thanks, everybody. All right, welcome back, everybody. Take your seats, settle in, and Tim, whenever you're ready, we can get back going. Thank you.
Thank you, Brian. I think you can hear me. If you can't, somebody will have to jump in and yell at me. Remember how we started? I said I was going to show a progression of successful change by saying that you need education in the fundamentals of bail, and I tried to show so far how the fundamentals of bail can really help you understand with the history and the law and what they tell you, everything all the way from the words you should use to, what maybe you should change to in the future to what are we trying to do, our goals. Those things all flow from the fundamentals of bail. And by the way, I wrote those papers in 2014. So some things have happened since then that are worthy of being in that paper. So if you ever want to know, just give me a call and I'll bring you up to speed on the things that have changed since we wrote the paper. So we have these fundamentals, and then I told you there's some pressure that happens usually, and then people start to mess around with their model, their release detain model. So let's talk a minute about this pressure. So to do this, recall that what I said in the federal system happened was after about 150 years of having this sort of bail system based on money, the federal system turned around and created the moneyless intentional release detain scheme from the Bail Reform Act of 1984. I called it the big fix. And I called it that because it fixed intentional detention and unintentional detention. I realize it's flawed in its structure, but it illuminates what becomes inevitable if you eliminate money or even reduce the use of money. You start finding yourself heading down a path of trying to do things on purpose. So what about the states? And remember what I said in the states was every single state had bail, no bail somewhere in their constitution or their statute, but every state had money. And so most of the states just completely ignored the bail, no bail dichotomy. Like you wouldn't even see them do any detention. They just use money as everything. And every single bail case was decided under the excessive bail clause. So you just didn't have much of a way out of the way things were. The status quo was going to remain that way. But now the states are changing and they're changing fast. I don't know why it is. When you look up the word change, you find a picture of a goldfish. I do like 5 different pictures of goldfish for changing. The states are rapidly changing. How are they changing? Well, there's different pressures that are being put on the states. One of the pressures is there's people that are wandering in the federal court and they don't even care about the excessive bail clause. They don't even mention it. They say, we don't care if that person's in there on purpose. We don't care if it's unintentional, intentional. What we say is if you're in there on a money bond, then state you have violated this person's due process and equal protection rights. Due process could be one of 2 things, substantive or procedural. Procedural is pretty easy, right? You can wander into a place and say, this guy didn't get any hearing at all. You just set the money and he's in jail. That's their procedural argument. And it's a good argument. It's the slam dunk argument of all of them. And you know how they look at substantive due process and equal protection are often done in the same way. And I won't get detailed on it, but realize that typically what a federal court's going to do is they're going to ask the government, they're going to say to the government, what are you trying to achieve? What are your ends? And they'll say, well, public safety and court appearance. And then the court will say, okay, well, how are you trying to achieve them? And they'll say, well, we're using money. And then they'll say, the court will say, okay, well, what's at stake here? And everybody will say, well, it looks like liberty's at stake. And in every one of these cases, these federal courts have said, yeah, it turns out we agree liberty is at stake. And because liberty is at stake, that means we're going to look at these things under what we call strict or heightened scrutiny. And what's that mean? Well, that means that the government has to show that their ends, public safety and court appearance, are compelling. And in every single case so far, they have. Those are compelling interests, public safety, court appearance. But then they have to show that money is necessary to achieve these ends, meaning nothing else but money will work. And the courts that really do the big work, they'll look at all the research on money bail and they finally say, you know, it doesn't look like money's necessary at all. There's all these other ways you can get people to come back to court and stay out of trouble. And money seems to be the least effective method. And that's why these people are winning in these federal cases, not based on excessive bail, but based on due process and equal protection. One of the best examples of a reasoned opinion is on a document that will be sent to you by Wes. It's the Harris County, Texas, 190-page opinion, where this judge went through all these sort of arguments and figured them out and ended up saying, you know, money doesn't work. And you start to see statements like this when you see these cases all around the country. This one, the last one was in Texas, this was in California, and it was looking at a bail schedule. And it said, you know, we look at the bail schedule and it just doesn't seem to be necessary. So that's the word, you know, strict scrutiny, heightened scrutiny. It doesn't seem to be necessary for public safety or court appearance. But the reason I throw this quote in is because now I've seen 3 or 4 cases in which federal judges have not only said it doesn't rise up to heightened scrutiny, it doesn't pass heightened scrutiny, but then they drop a line like this case did and say, you know, in fact, this thing seems so arbitrary that we don't know if this schedule even satisfies the smallest amount of scrutiny we can apply, which is called rational basis scrutiny or rational basis review. Folks, you don't have to be a lawyer or a judge to know if something simply doesn't make any sense. If it's irrational, it is on its way out. And court after court is even though they're holding money bail up to a stricter standard, they're also saying, we don't even see it passing rational basis review. That's a big deal. Futures more lawsuits like this, more groups, more legal theories. I wouldn't have chosen equal protection as my first theory, but they did, and they keep winning. The lawsuits take away money as a detention mechanism. That leaves the state with the net and process for intentional detention. And by the way, it doesn't happen just in the federal court. One of these cases can come up out of the blue. This was from the state of New Mexico Supreme Court, a case called State versus Brown, in which case the New Mexico Supreme Court, they didn't even look at any federal law at all. All they did was look at their own state law, which looks like every other state law I'd ever seen, and basically wrote a 50-page opinion saying, judges, you're doing bail all wrong, and we have to change. This one opinion, State versus Brown out of New Mexico, led to New Mexico having to change their constitution, all of their rules, everything that they do about bail was upended due to one single case. That's pressure. By the way, I saw a case recently out of Texas, or out of Virginia. I know this is not the kind of case that has any kind of precedential value. Apparently, it doesn't even have precedent over the judge who wrote it. But these quotes are indicative of me seeing a judge making those sort of big questions about money bail. When I first started to study money bail, I just asked myself, I go, it doesn't seem like this money makes any sense. It seems arbitrary. And in fact, it's incredibly arbitrary. And when you start to see more and more judges really think deep about it, what you see is this groundswell of people realizing that money bail has only ever had one reason for its existence, which is that it keeps people in jail easier than a system of intentional release detained. This all begs the question then. So what is your system? Any state I go to, I say, look, money's going away as a detention mechanism. You need to figure out how you do release detain on purpose. Another way that change is coming is this. I don't think Illinois had any big court cases forcing them to change. But there was lots of education going on up there. And then suddenly, all these organizers, grassroots groups, civil rights groups started to put an enormous amount of pressure on the people in Illinois. And they got everything changed. Illinois, just in the last 6-8 months, changed. They took all money out. There's no more money bail at all. And they created an intentional release detain scheme. So this is just kind of pressure you can see from these groups. And these groups are just now starting to get involved in bail in the last couple of years. Now, I could spend a lot of time and show you how money as a detention mechanism might go away, but I want to just focus on the one in yellow. And that's simply this. If all you do is decide, well, we want to start doing things more, more transparently. If we want to keep someone in jail, we want to do it intentionally. We want to do it the right way. And if we want to let them out, we want to do that the right way. You are automatically heading down the same path as if some federal court said you have to use your intentional release detain scheme. Just the decision to do things on purpose means you are automatically heading down the same path of having to change your model. And finally, I bring this up because this really matters to Virginia, I think. There are people who have now gone into court 3 or 4 different times, and they're taking the no bail provisions that exist in a state, at the time it was a state constitution, and they take a no bail provision and they go into a federal court, or in one case it was a state court, and they say, you know what? You remember that case Salerno from 1987, that second Supreme Court case that we often ignore? It said that detention provisions have to be carefully limited. Well, we're looking at this no bail provision in this one state, and it's not carefully limited, and they're winning. And in some cases, these detention provisions are 20 years old. They've been on the books in the Constitution for 20 years. But it's true, if you start to apply Salerno and this notion of being carefully limited to a state bail scheme, I can tell you that every single state no bail provision is at risk right now. So really, if I came to any state and said, by the way, money as a detention mechanism is going away, that leaves you with just whatever you've already written about intentional release detain. And by the way, we're starting to look really hard at those intentional release detain things, and we're finding that a lot of the detention provisions are too broad. What would you do? Your best bet might be to start completely over. with a new model. And that's where we're going to talk about how to do a model. Now, this came to me. I didn't want to do a model, by the way. I didn't want to have to get involved in this. But remember, I wrote these two papers. The first paper had all the fundamentals of bail on it. And the second paper, I said, okay, if you follow the fundamentals of bail, here's how you'll set bail. It's going to be an intentional in or out decision on, nothing standing in the way of the in and out, that kind of thing. And remember, I dropped a footnote in each paper and said, yeah, and you may have to change all your laws to make that work. Well, as soon as I wrote these papers, people started to yell at me and they said, you need to write another paper. You need a third paper. You need to tell the states to what do they change? What should they change to? I didn't want to write it, frankly. I tried to get, you wouldn't believe all the people I tried to get to write it, and they didn't want to write it either. But then I started to think about it, and I said, okay, wait a second. I know how we used to do bail or how we're doing it in the States. We look at your charge, we throw down some money, we wait around. I see what we're doing. I see this new generation of bail reform. We have different ways of assessing defendant risk that seem better than just looking at your charge. We're using less or no money because we see that gets in the way of everything. And we're trying to do things on purpose. And the more I focused on this word risk, the more I realized, well, maybe I can pull this off. I knew what the sort of the bumper sticker slogans were at the time, back when I wrote my paper. There were people saying, we're moving from charge to risk. We're going to go to a risk-based system. We're going to detain all high-risk people and release all low and medium-risk people. And I thought, this has got to be the key to it. So I figured what I can do is I can change everything to be a risk-based thing. And here's how I'll do it. Every state has bail, no bail, and a limiting process. What I'm going to do is tell them, change all that and stay, whether it's in your constitution or statute, just say, we're going to release all low-risk people, and we're going to detain all high-risk people. And we're going to use an actuarial tool to figure out who's high risk, who to detain. And I thought to myself, I go, man, it's got to be easy. That's going to be 10 pages, a 10-page paper. This will be cake. And then I started to think about it and write it. And I ran into some bad hypotheticals. I said, okay, wait a second. If I'm going to release all low-risk people, then what do you do with the super low-risk person who is nonetheless in on a really high charge? And we call that the son of Sam hypothetical, because son of Sam, who was a serial killer, apparently got given an actuarial tool and he scored low. Okay, dang it, I got to build that into the model. What about this? What if he's a super high-risk person and he's in there for stealing a candy bar? Oh man, I got to build that into the system too. And then that starts to implicate legal foundations, right? Because excessive bail is basically that. It's saying, well, detention is a little excessive for the guy stealing the candy bar. So now I got to worry about all these legal foundations. And then I ran into this, due process, fair notice. What's that? Well, due process, fair notice is how we do our criminal system. In America, we take all the laws, substantive, procedural laws, bail laws, we put them on the books so everybody can see them. And as long as they're not vague, as long as they're clear, due process says people can look at those laws, see what kind of things will lead to jail, and then walk free down the street, managing their lives so that they can stay out of jail. It's important that we give them fair notice. Well, if I tell you that we're going to release all low-risk people and detain only high-risk people, what's your first question? My first question would be, how do I keep from being high risk? And the answer is you can't. You're either high risk or low risk right now. We just haven't assessed you yet. Or maybe we did assess you, and now we're just waiting around for you to do something wrong. That's a problem. That's a huge problem for my model, this risk-based model. And then I started to think about the tool, and I thought to myself, okay, what about this tool thing? Now, I'm a fan of actuarial tools. When it comes to releasing people, I think they're really helpful. And I actually think there's a place for them over here. But mostly when you're releasing people, they can be really, really helpful. But I said to myself, but if you're going to use them to detain people, I don't know, it better be tight. And I knew people across the country were using these to detain people. They were creating grids that if you were high risk, you'd be detained. So I thought to myself, well, let me look into these things. And the more I looked into them, the more I realized, well, they're not as tight as I'd like. For instance, let's use the Colorado tool as an example. In Colorado, we have what's called the CPAT, the Colorado Pretrial Assessment Tool.
And on the CPAT, you're a 1 through a 4. Now, we don't use the word risk, but everybody knows if you're a 4, you're higher risk than a 3 or a 2 or a 1. So if you're a 4 on the CPAT, what does that tell me about you? It turns out it doesn't tell me really anything about you. It tells me you look like a group of people with similar characteristics who, when we administered the tool, came out with 4. You could be the best defendant we ever had in our lives or the worst. We call that issue the individual/aggregate issue. Well, it's important stuff to know what someone's risk is, even at a group level, but that may not be tight enough to detain somebody. What about court appearance? What's it tell me if he's a 4 for purposes of court appearance? Well, in Colorado, and like every other tool, it says that the number 4 is higher risk than a 3, 2, or 1 to miss court for any reason whatsoever. Okay, if I'm releasing everybody, that's important stuff to know. Because if I can see a 4 on there, I know I can put my resources on the 4 person and help give them supports and help them get back to court. But detaining, we've never allowed detention for risk of missing court for any reason whatsoever. In America, we've only allowed intentional detention for extreme risk to flee to avoid prosecution. What about public safety? Same thing. If you're a 4, you're higher risk than a 3, 2, or 1 to commit anything from a traffic violation all the way to murder. Okay, if I'm releasing everybody, helpful stuff. But we've never detained anyone in America for the risk of committing any old crime. When we've allowed it, we've only allowed it for extreme risk to commit a serious or violent crime. So you see, I have problems. I have legal problems and I have research-based, evidence-based problems. I don't know that I can do this risk-based detention. And so the more I thought about it, and in fact, it's funny that Mike's here because he and I kept meeting over the months when I was writing this. And at one point in time, he said, maybe you can't do it that way. And that's when the light bulb went off. And I said, you're right, I can't do it that way. So I turned around and I wrote the way you can do it. And I have the answer. It's written in a paper I call Model Bail Laws, redrawing a line between release and detention. Somebody said my model bail laws paper was too long, so I wrote a shorter summary of it called Changing Bail Laws, which is only 60 pages. The first one's 200 and something pages. I call it Plan B because it's a moneyless release detain scheme. And what I realized by doing all this research and laying it out in terms of how we can detain people on purpose, how we should use money, all these different things, is I realized that there's certain things that a moneyless model needs to have. First of all, you're going to have what I call the primary net and limiting process. Now, primary net and process is just what you know to be bail. It means we're just doing something based on prediction. Primary net, though, can't be this unlimited thing, or it can't just be based on high risk. It has to be a limited, charged-based net. And as I found out through many, many pages, you can't detain by using a tool. They're just not cut out for detention. It's also going to have a limiting process. And by the way, a limiting process, my limiting process, I'm actually very proud of. I worked with it with Mike and about 5 other people, all very smart people. And we looked at every single limiting process across the whole country and we realized, wow, they're all really bad. But we came up with a limiting process that is really good. It solves those problems with the individual aggregate problem. It solves the what we call the risk of what problem. It lays out in about 8 elements all the ways that you could set up a limiting process so that your net, you're only actually going to detain people in the net that are truly the risky people. You're still detaining based on risk, but it's what's articulated in the process, not through a tool. The good thing is, the amazing thing about my limiting process, which I found, is that it cures a wide net. If you go into a state and you end up having a very wide detention eligibility net, the limiting process can cure that. Now, you're also going to have in a moneyless model something I call a secondary net limiting process. You know it as bail revocation. Typically, states use that as a sort of a throwaway thing. Bail revocation is so easy to do. It's just like, well, if you screw up at all, we can revoke your bail. I'm trying to get states to think of it in terms of a secondary net and a secondary limiting process, which is looser than the primary, but which gets at the same thing we're trying to get to, which is they're in the net, but are they risky? Should we actually detain them? The wonderful thing about this model is if you have a good secondary net and process, you can cure a narrow primary net. That's what's amazing and how these parts work together. Most importantly, a moneyless model's got to be lawful, and the most main important part of it, which we'll get to when we talk about Virginia, is it has to be carefully limited. That phrase that I talked about from Salerno about detention comes from a quote that says, "Liberty is the norm, detention has to be carefully limited," and you can learn what that is by reading the case and other cases that decide or my model. Bottom line is, you need to know the risk research to do a moneyless model. It's really, I couldn't have done it without diving into this risk research. I couldn't, the more I learned about defendant risk and what goes into making these actuarial tools and what is it we know about defendants, the more I was comfortable with my model. And I'm still comfortable with it since I wrote it in 2017. You know, this risk research tells you a lot of things, but one of the first things it told me is that defendants simply aren't that risky compared to a lot of other things. They're certainly not risky enough to do the things that usually lead to detention, like risk of flight or risk of committing a serious or violent crime. And by the way, the risk research also tells us that those things are incredibly hard to predict. They might even be impossible to predict. The more you understand the research, the easier it is to create an intentional release detain scheme. Because the whole thing is line drawing. All you're doing is drawing lines. And once you've drawn a line on intentional release detain, realize what you've done. What you said is that everybody before this line, we don't care how risky they are. We know right now they're walking around the streets and they might be high risk. They're just not going to be triggered. They're not going to be eligible for detention, even though they're high risk. So read the paper and you'll see what I'm getting at when it comes to line drawing. If you get to this point where you're doing the line drawing, then give me a call because I can give you a lot of tips. There are other models besides mine out there. Although mine, I got to tell you, the good thing about my model, besides the limiting process, which is really, I like, is it's got justification like you wouldn't believe. 200 pages of justification. And you're going to see in a minute how the law requires you to justify your detention provisions. Well, it helps. I have all that justification in there. You could create a model out of the standards. Remember, I told you I wasn't going to talk about the standards, but you could take them and create a model out of them. It might be hard. CRC is Civil Rights Corps. They have a model. ACLU has a model. They call it their vision. There is the federal model, the DC model, New Jersey, New Mexico. People tend to look at those. There's problems with those, though. You should read my paper to see what those problems are. Most recently, the Illinois model is out there, came after my paper. In fact, they used my paper. So there's parts of it that I like a lot. Some parts I would do different. And one of the most recent ones is from the Uniform Law Commission. It came out last year. You might know the Uniform Law Commission. They created the Uniform Commercial Code. So they're well known. They've been around since the 1800s. And they created a moneyless intentional release detain scheme. Now, the way they did it is a little odd. So they've got an issue that you have to deal with. And so my only point to you now is realize the ULC has a release detain model out there. And there's going to be people in your state that are going to want to try to get it enacted. But if that happens, you're going to need to call me because you're going to need help. And in fact, I wrote a paper to help you with that. What to read, what I would take is I would read these papers I've written about models, and I would read them in reverse order. If you go to my website, on the very first page, it talks about the biggest issue in bail today. That'll just give you 15 pages with no footnotes. Then read Changing Bail Laws, which is the 60-page paper. Then, if you feel like it's time for us to dive into the Virginia model, you're going to want to read Model Bail Laws. And if you use the Uniform Law Commission Act, you're going to need another paper I wrote that's on there. So now let's turn the corner. This is what we've been waiting for, right? I'm going to talk about Virginia. You are a very unique state, primarily because you don't have a constitutional right to bail. You are like one of 9 states that has no constitutional right to bail provision, which can actually be very helpful. Now, personally, I like right to bail provisions, but I've seen the chaos they cause. They're hard to change. People don't know what they're talking about when they talk about them. So it can be very helpful. You can do things very quickly in Virginia without having a constitution to worry about. The first question, of course, that comes up when you say that is, well, does that mean we can detain anyone we want? I could spend 3 hours explaining why, but you just kind of have to take my word for it. No, you can't detain everyone. This sort of right to bail transcends all laws. I do talk about it in my model bail law paper. You have to do what Salerno says and release most people, and you can detain some people. Well, then if not, what are the boundaries, right? Well, most states that have a problem is that their no bail provision is too narrow. What they see is money goes away and they go, oh my God, money's going away. But our no bail provision is really narrow. Perhaps it's only capital offense. Maybe we can only detain capital defendants. And it's in our Constitution. We can't even change it without going through this giant process. You guys are very, very different in two big ways. One is it's not in the Constitution. And two, your detention provision is really, really wide. So to get a grip on what your bail, no bail provision is, which is in your statute, the first thing I read, and forgive me if I read it wrong, but I went to your magistrate's manual because it talks about things sort of differently than the way the statute reads. And we'll get to the statute. But right off the bat, the magistrate's manual cites to Schnacke versus Boyle and says basically for the basic premise of pretrial release. Now that's a good case to cite to because Schnacke is a release-oriented opinion. That's for sure. Schnacke versus Boyle equates the right to bail to the right to release pretrial, the right to freedom before conviction. And then it says, Virginia law has restricted that premise to cases in which the defendant doesn't pose a flight risk or a threat to public safety, cases not requiring a secure bond, and those cases not covered by this other extradition clause somewhere. What's the problem? Well, the main problem is that detention provisions really aren't analyzed under Schnacke. So when you're talking about restricting Schnacke's premise, you really have to start asking yourself, how does it fare under that second case, Salerno, and the requirement that detention be carefully limited? Now, if a court looks at your whole provision and a court is going to decide whether it's carefully limited or not, they're going to look at the whole thing. This is what makes it kind of confusing. They're going to look at your net, your limiting process, the fact that you have no constitutional provision shouldn't matter. They're going to just kind of go from what you have, how you use money. Did you justify it lawfully? Is it justified in a lawful manner? That's how they're going to look under this stuff when you read the cases on what carefully limited means. So what's your bail, no bail provision? This is from your statute. Person held in custody shall be admitted to bail. That's bail. These people shall be admitted. Everybody gets admitted to bail unless there's probable cause to believe no bail. He will not appear for trial, or his liberty will constitute an unreasonable danger to himself, family, household members, or the public. That is your bail, no bail articulation. That is your articulation of what most states have in their constitution, but you have in a statute. You're saying these are the on-purpose release detained provisions we have. So what's your detention eligibility net? Basically any charge. It's what I call an unlimited net. You're still detaining based on risk, but ask yourself, is it the kind of risk that we've always required in America to detain people? Now, you may not know what that risk is because you'd have to read my big long paper for me, because I walk through the whole history of detention, on-purpose detention in America, to come up with why it is we've only ever detained people for extreme risk to commit serious or violent crimes or to flee. Your further limiting process is probable cause to believe the person won't appear or he'll be unreasonable danger. Basically, this further limiting process is pretty loose. We'll get into it in a second. So you have an unlimited net, an incredibly loose limiting process. Now this tells me when we're looking at the net, I want to just mention this again. Due process fair notice is often called the first essential of due process. The Supreme Court will call it the most basic of due process. And this is the reason we have it. It's supposed to give ordinary people fair notice of the conduct it punishes. And to protect, there's other reasons. I just focus on the one, but it's also to protect against arbitrary enforcement, separation of powers. When I wrote my model bail laws paper, due process fair notice was one of the main reasons why I said we have to stick to the way we've been doing things in no bail for a long time, which is a limited charge-based detention eligibility net. Right now, if you were to look at the law and say, we just want to follow the law today, you would look at Salerno and you'd say to yourselves, well, Salerno liked the fact that it was limited by charge. The net was a limited charge-based detention eligibility net. And I make a case in my model bail laws paper for why we should stick with that and maybe not move into this new realm, what I call hypothetical future law, in which you could detain based on just sort of amorphous concepts of risk. Because due process fair notice would say, people won't know what to do. And when I wrote it, I have to admit, I wasn't on this most solid ground, because I wasn't even sure, for instance, that I had never even found a case where any state Supreme Court had used due process fair notice or vagueness in a pretrial setting. Maybe it only dealt with sentencing. I didn't know. Well, since I wrote my paper, I've seen now 1 or 2 state Supreme Courts apply vagueness to a pretrial detention provision. And I've also seen this. The US Supreme Court has now been articulating more and more stuff about what it feels about vagueness. That, for instance, it doesn't have to be a criminal, purely substantive criminal case for vagueness to apply. It could theoretically apply to something like pretrial detention, which the Supreme Court has said is not necessarily punishment, it's regulatory. But look at this line that came out of a case called Demia. And this line was repeated not only in the opinion of the court, but also in Gorsuch's concurrence. And it talks about the net. And it says, you know, if the legislature could set a net large enough to catch all possible offenders and then leave it to the courts to step aside and say who could be rightfully detained and who could be set at large, this would substitute the judicial for the legislative department of government. This was one reason why Justice Gorsuch and earlier the full court said, yeah, you can't just set this unlimited net because separation of powers problems kind of occur. So let's look at your limiting process a little closer. Your limiting process says that once you're in this net, which is everybody, then you have to find probable cause to believe you won't appear or the liberty will constitute unreasonable danger. Like I said, this is about as loose as can be. These days, it seems pretty clear that most everybody agrees that probable cause is not the right burden to use for detention provision. I've seen really good briefs saying that it's supposed to be clear and convincing evidence. Look at these things you're looking at. You won't appear for trial. You're not looking at flight. You're looking at just non-appearance, unreasonable danger. You know, it's just very loose. What's unreasonable mean? The limiting process to me just seems like it's not going to help you if someone's going to be looking at your provision in terms of whether it's carefully limited. And then we have how you use money, which is a whole nother way to get detained in Virginia. If you can't meet conditions, you can remain in jail, and then the magistrate creates what is called a commitment order. So that's a whole nother way to stay in. And if a court were looking at how it is you do release and detention in Virginia, it would note that this is one of the ways you can be detained. Well, money-based detention raises a whole slew of other issues, right? All those things I talked about before, about due process, equal protection, excessive bail, all those things together, in addition to the fact that it might not be carefully limited. So what's your secondary net and process? I was looking for that too. Now, don't feel bad about this because to most states, bail revocation is like a throwaway thing. You just one-line it. And sure enough, in Virginia, you can be violated for any term or condition, or even if it appears that bail should have been denied, or if you're arrested or convicted. So those are all things that can land you in the net to be revoked. And your further limiting process, I got to tell you, I looked for it and I couldn't really find it. It seems like what it is probable cause to basically believe the allegations that have been brought. So it's very, very wide open and loose. And realize if you're crafting a new model, you would want to work on this. So once you know everything about models and you know how your model exists and you know all the ins and outs of creating a model, you can start to judge a model. And one way that I did in my paper was I listed 3 different ways that you can really judge a model. You don't have to do it, The main way is this legal way. It has to be legally justified, carefully limited, can't offend certain fundamental legal principles. But a second way you can judge it is just to ask yourself, is there any way we could narrow this further? And if you read my entire paper, what you're going to see is I finally have a whole sort of a 5-page thing that says, because of all these reasons, let's be 50, 60 reasons, we should constantly be asking ourselves whether we can narrow the detention provision further. And you need to provide reasons for why it won't. You have to justify things. Too many states have created detention laws that are simply unjustified. And then I have the most difficult to realize is this. There's a lot of scholars out there, real smarty dudes, that talk about threshold requirements for all predictive models. So we'll talk about that, but let's go through them real fast. Looking at the Virginia model right now, your release detain, intentional release detain, and the whole way you do it, all the details, I have to say that if you have an unlimited net and a loose to almost zero limiting process, that it's not limited, certainly not carefully limited. When you use money that leads to detention, not only is that going to raise all kinds of legal issues like due process, equal protection, but it's just a careless way to do detention. You have no idea whether it's going to work or not. Now, the good news is making a detention provision carefully limited can be done in a lot of ways. And there's all kinds of ways to shift things around to make things more palatable. For example, I fully believe that most states will err on the side of having a wider net. And it's, if you read my paper, you realize that that's kind of easy to do. The justification needed for the net is less than for certain other things. But you can offset that by working with the limiting process. So you see there's all kinds of ways to make it work. Second way of looking at models, can you be narrowed further? Well, in the case of Virginia, absolutely, because you have it's not narrowed at all right now. And finally, this notion of requirements for predictive models. Realize that out of all the requirements that they talked about, these smart professors, to me, the most important part of this was they said you really need procedural due process protections because it's prediction. And these are things that I just couldn't find. I didn't have much time to go through your statute, but I did not see in your statute the things that I look for in other state statutes that say, when you have a detention hearing, this is what happens. Lawyers are present. There's a time period for which everybody gets ready, and then there's evidence that can be introduced, and then judge has to make a finding, a clear and convincing standard of proof, and all these things. I just couldn't find it. Now, it could be that somewhere you have a court case that says, no, they're not in the statute, but here they are. And I've done, certain states have that, but I wasn't given the leeway to look at the court cases. So given all that, let's reimagine bail for a second in Virginia. All of the fundamentals of bail seem to point to the same thing. The need to remove money as a detention mechanism and then to replace that with an intentional release detain scheme. In Virginia, there is no need to bother with your constitutional right to bail clause because you do not have one, but your statutory detention provision needs to probably be reworked so that it's carefully limited. My 3 papers, along with other models, and we didn't have any models prior to 2017, can provide guidance. And between you and me, because every state has a model and a federal model, all these models exist, the hypothetical models, the ones done by me and Civil Rights Corps and ACLU, and even the Uniform Law Commission are better than looking at any state model that's already in existence. So don't follow down the path of saying, let's just go and do a survey of all the states. They're mostly really bad models. I would look at the hypothetical models first. The hard part is going to be this, the fact that Virginia has a long history of being able to detain anybody pretty easily. And what we call this, when you change something like this, you're calling it an adaptive change or cultural change. Anytime you set limits on something like this, it's really, really hard to do. So it takes a bit of work, a lot of education, a lot of work. There's people that specialize too in helping you overcome adaptive changes. But you have a lot of things going for you. I read this really fast, and whoever wrote this document really knows what they're doing when it comes to bail. And this was written before my model. This got it right. This actually said the same things in a couple of paragraphs that it took me 220 pages to say. So you have a lot of people that know a lot about bail. You have some phenomenal statewide systems that are already in place in Virginia. You have, I think you call it the model, the pretrial model, which is actually the VPRE. The rest of the world calls it the VPRE. So you have really smart people that have helped you with these assessment instruments and helping you with this guidance. You define bail as pretrial release. Your definitions are good. You have judges that are clearly starting to think differently about money bail, because I saw that one case. They're asking the hard questions. You've got a track record that's really good. The last time I came out to Virginia, I spent the whole time talking about rebuttable presumptions toward detention. You had about 50 of them. And I kept talking about how there was no place in an American bail system to have them. And now you've gotten rid of them. You've got a track record of really doing some very good things. You don't have that constitutional right to bail, which can actually be a good thing. I like when states have them, but it's not that big a deal. And then you have all the answers. Like I said, there's no reason now that you can't dive in. And that means basically one bill away from leading the country in pretrial justice. Illinois did a big thing a few months ago. It's going to take them 2 years to implement it. You could do this very quickly. And I think you have all the moving parts to make it done. So with that, I'm going to end, and we have a little time for questions as long as we take that break before Mike starts at 5 till. This is, by the way, is my stuff, my email address. And if you go on my website, you can find that also, or my phone number. And I'll stop sharing. I'll give it 20 seconds.
Tim, I have a few questions while we wait to see if anyone else wants to put in some questions here. So
Okay.
I have a question about detention eligibility nets. So we just got rid of our rebuttable presumptions against bail. And I think there's a worry among some people who think about this, that if we put in a detention eligibility, whether it's you can't do no bail on misdemeanors, you can only do no bail on violent felonies, whatever it happens to be, that's essentially put back into our law this idea of a rebuttable presumption that judges are going to say, well, this is a no bail offense, so I'm going to hold this person without bail and make getting people out on those charges. Has there been that type of thing in any other state, or what do you think about that idea generally?
I wouldn't blame you for thinking that if you didn't double up the net with a limiting process. Because if a judge looks and says, well, gee, this looks like the presumption is now on them, although this would say it's not on them. The limiting process with my 8 elements is going to say clearly it's the government's role to prove by clear and convincing evidence. So now here's the interesting part about your rebuttable presumptions toward detention was actually, I think that was people's initial thought process of coming up with a net. I mean, really, those were the cases that people seemed to think, well, those are the ones that we should detain, right? They were thinking in terms of these are the ones. Now, it was just done the wrong way because bail should never have rebuttable presumptions toward detention. It should always be presumptions toward release. The government should always prove by clear and convincing evidence the need for detention. And all those things have to happen. But I think when you had the rebuttable presumptions, we had conversations with people in Virginia where I told them, I said, this is just your first shot at thinking through a net. Now, realize what you would really do if you're thinking through a net. And the way to keep them from being really bad, like the rebuttable presumptions, is to make sure you do this too. The further limiting process has to be done in conjunction. When you're drawing the net, though, you're drawing lines. So the first question you might ask would be, well, should we detain anyone at all? It's a good question. Now, everywhere I've gone and every time I've asked that question, someone has always given me a hypothetical that says, yeah, okay, we all agree that person should be detained. That means you have to come up with your process. So then your second question is, all right, we're going to create this process. We start with detention eligibility because that's what the current law is. And that's what we looked into future law. We don't think it should be any different. Who should be eligible for detention? And you might start at the ends. You might say, well, what about first degree murder? Should they be eligible? And everybody in the group will say, well, yeah, I think so. Okay, we've done that. What about parking offenses down on this other end? No, nobody parking. They shouldn't be detained. We don't care how risky they are. It could be the riskiest guy we ever saw in our lives. No, we're not going to detain based on parking offenses. So you've drawn a line, haven't you? Now, as you draw that line, it gets a little more difficult. You start moving into traffic cases. And you might decide, yeah, there's certain traffic cases we just don't care. But here's one we do care about. Maybe DUI is different. Misdemeanor, same way. There may be some that you don't have. And pretty soon you've created a net. Now you have to justify the net. You can't just say, well, we just did it because we just don't like all felons, so we chose all felonies. You want to have a little bit of justification in there. My net in my model is justified primarily empirically. My net is violent felonies or violent charges. So it includes violent misdemeanors and violent felonies. But so it's justified through some empirical evidence, but also by common sense. And the notion is that if you commit a violent crime, you should expect that something different may happen to you. I realized I wasn't as concerned about a wide net. And the people I worked with, which included people like Alec Karakastanis and Mike, some people who are really big time civil rights people, we all came to agree that the net was less important than the limiting process. So yes, when you're doing a net, you got to justify it, you want to choose it. But if you get a little wide on it, it's not that big a deal as long as this further limiting process is done well. And if anybody's in the room and they're saying, well, I still think the net's too narrow, there's not enough people in our net, well, you can help them through that secondary netting process, which is bail revocation. If you make that proper, right now, it seems like it's a throwaway in Virginia, but if you made a really good one, you would probably pacify even those people who thought the net was too narrow.
Let me ask you, I'm going to rephrase another question that we got in here. Like everything, changing statutes boils down to politics. Throughout the country, I think bail reform, it's happened in Virginia. The pretrial process gets conflated with the post-trial, post-adjudication process and whether people are guilty or not, and it's used as a political football. So in Virginia, where we have to deal with this, like all the other states, what can you tell us about how either people have found common ground despite their political persuasion on the need for bail reform, or the different cases for bail reform that different political parties might make, or the feasibility of doing it under people with different ideas about what I'm going to call law and order and how we deal with that?
It's kind of too bad. When we started, bail reform was not political at all. And I would go to these meetings where the Koch brothers would be sitting there and National ACLU would be sitting there. It's only kind of become political sense, but everything's political now, right? But I'm convinced that if you spend time doing sort of deep education with people, I think people are able to come together and create new models. And then the key is to have a really decent group of folks that can dive deep into the education part, create ideas for a new model, and then present those to larger and larger groups. So in Colorado, we had a very conservative judge. He was a prosecutor. Sit down with someone from ACLU, sit down with a defender, sit down with a chief of police and a judge and two other people. And they sat down and they found common ground based on my sort of model paper as to what to look for. And they rewrote the Colorado Constitution to have a new net, a new process, and they all agreed to it. Now, they don't have any pressure in Colorado, so that sucker got stuck on a shelf. No one's done anything with it. But they were ready, and they're ready in case money goes away. See, we use all money to keep people in jail. You guys do a combination of you have a lot of people in there on no bail, and then you have some money. And the reason you have the no bail is because it's so easy to do. Most states in their law will have something about a detention hearing, which makes it harder to detain than it does in Virginia. And just the fact, when you get to that point where you realize, wow, it's harder to detain this guy this way, well, I can set the money, as long as I don't say anything, that'll lead to the same thing. I would start by just trying to find, frankly, I should have Mike chime in if you want to, Mike, about creating coalitions, because Mike is the king of this. He gets with groups and he just brings all the people together. And then you find that you all agree on the same things. And then it's just a matter of just having more and more education about, well, what does it mean to do this and this and this? And what can we just push out the window? We don't even have to think about that because it's wrong. We don't have to think about this stuff over here people are saying, because that's not a part of it. And then we focus on the task at hand. Mike, you got anything about that?
No, thanks, Tim. I don't know that I'm the king of anything, but I hear what you're saying. Whether you're working at the state or local level, it's important to have, as with anything, the right folks at the table, the different perspectives, be it political, be it social or racial, or whatever the objectives are. And yes, I and many others have worked on bringing those groups together in a collaborative fashion. It's just a matter of if they have the will to do so.
I don't think politics, it's necessary to this process. That's the thing, because I know that it existed without politics. I think politics has infiltrated kind of every part of our life, but that doesn't mean we can't all sit down and say, in this one spot, maybe we can remember a time 10, 15 years ago when there was absolutely no politics at all, and everybody was on the same path of making certain changes. Everybody believes in public safety. Everybody believes that people shouldn't be in jail just because they can't afford to be there. And if you start with that, then you start to see some common ground.
And maybe for either of you in the kind of couple minutes before we take our break, in Virginia, like all states, there's a big urban-rural divide in how we do, especially when I think about a further limiting process and how often people have court, how easy it is to have court, how easy it is to get lawyers there, and resources, especially in counties where you may not have any lawyer, a part-time prosecutor and a judge who only sits there once a week. So when we're thinking about creating a statewide regime that has to deal with big cities or big suburban jurisdictions, as well as rural, under-resourced areas, and it may be also under-resourced in terms of pretrial services, how can we think about that broadly to make sure we're getting everybody included?
Some of those things are, they're going to be important things. And if you sit down in your group, everybody's going to bring up this notion of, well, there's some places that are just not like the big city places that are rural. They don't have the resources and everything. But realize some of the things I'm talking about today are things that are going to be thrust upon you because the Constitution of the United States requires it to be done. And there's just no excuse. At some point, you have to say, we have to have procedural due process before we detain anybody. And if you don't have that, you have to have it everywhere. It's kind of like the probable cause rule. We didn't just say, you got to have probable cause within 48 hours only in places that can do it in 48 hours. It's a constitutional issue. So there's going to be some things you can work with. And so many states have already done so much with rural areas and urban areas that I think you could find a lot of help from other states.
And specifically, Brian, most recently, the state of New Jersey, they have some very urban areas, and looking at the map, they look like some pretty rural areas too. And so operationally or practically, they may be able peer-to-peer to give you some guidance on how they deal with, because they have that bail, no bail dichotomy, right? They got a new constitution, new statute, new procedures, trained a bunch of people. They have a pretty good further limiting process. And so, they made it work statewide, and their statewide outcomes after several years are looking really good.
New Jersey is also interesting because it compares to Virginia pretty closely in terms of both crime rates, crime types, and population. So despite being a little bit, you think they're a lot more different than they are when it comes actually to this space. I'm not seeing any more questions. Why don't, if it's okay, we take a 5-minute break now. People can think about their questions. We'll come back with Michael's presentation, and then we'll have a little bit more time for questions at the end. So let's be back right at 4 o'clock, and we'll pick up with Michael's part of the presentation. Thank you again, Tim. See you all in 5 minutes. Everyone, welcome back. Grab a seat, settle in. Thank you for sticking with us. And Michael, take it away whenever you're ready.
All right, thank you, Brian. Well, good afternoon, everybody. Thanks again for hanging in there. I know a 3 hours time commitment in front of a video screen is a very long time, so I greatly appreciate that. Brian, can you just confirm that you can see my screen?
Yes, I can see and hear you. Everything looked great.
Awesome, wonderful, thank you. All right, so what I'm going to talk about today complements very well what Tim talked about the past few hours, and that is what the research findings say around pretrial justice and the implications of those findings. And I think that is necessary as you endeavor to reimagine bail in 2020 and beyond in Virginia, because you need to know what the research says. As Tim pointed out, that what the research shows is effective or not should influence what gets put into the law. Just as the law will tell us and guide us where we should focus our attention on the research, right? There's no point in researching something if it's not lawful. So moving on with that, I am sharing our time today on behalf of APPR. That's a national initiative advancing pretrial policy and research. It's supported and funded by Arnold Ventures, right? That's a very large and active philanthropy. They do a lot of work to try to better people's lives in many different areas, one of which is criminal justice, and within that, more specifically, is pretrial justice. APPR, real quick, has a couple big goals. We say, well, what exactly is that initiative focused on, right? We try to shape the national dialogue around pretrial justice. We've developed a community that supports pretrial justice, practitioners such as many of you, advocates, elected officials, appointed officials, the public, the media. There's a lot of good information and sharing that can go on, supported by APPR. And of course, the end goal is really to build all states, all localities' capacity to have a more effective and fair pretrial justice system. Now, APPR maintains an amazing website. There's probably parts of it that are updated and added to on a weekly basis. That is here, and I'll show you. There's a lot of awesome information for just about any of those groups out there that I mentioned earlier. And you can access it right at the top through this link here at advancingpretrial.org. You can find a lot of different things. I just listed a few here, some research summaries, there's legal analysis, there's a glossary. Remember Tim's sixth area in the fundamentals, that language matters. There's announcements for trainings that occur, and I know several of you who are on with us today have attended some of those trainings and will do so again in the future. Another awesome part of the APPR initiative is the pretrial community. I think there's well over 1,000 members now. It is people just like you who get on there, they post questions, comments. Basically, it's a way to talk peer-to-peer about whatever's on your mind, what you want to know. So I encourage you highly to sign up for that. And when you sign up for the website, you'll also get the APPR newsletter. I think it comes out like maybe about once a month. And that is a great way to keep up with what's happening nationally. What other states are doing. Sometimes it's new publications or studies that you might be interested in about the topics we talk about today, for example, or it's just new the story Tim described about Illinois. That was mentioned in the on the newsletter as well, and there are people from Illinois in the community, so you can pick their brains about what has worked for them so far or not, as you work on similar issues in Virginia. And then finally, part of the APPR initiative is we have a lot of experts who provide technical assistance in a number of ways. We have the PSA or the APPR help desk. We can ask questions about the PSA or other kinds of pretrial issues. And in particular, there's what we call learning sites. It's a way to receive some free technical assistance through the APPR project. May be something that you are interested in as well to tackle the kinds of issues you're thinking about. So with that said, let's go ahead and do a warm-up opinion poll. So what I'm going to do today is I'm going to talk about the research, and we are going to use Zoom's poll feature. So here it is. Remember Tim said the 3 M's? You have to balance those. Well, for today, for research purposes, I'm going to make you not balance those right away and just prioritize them. So if you had to rank one of the 3 M's as primary, like which one is most significant or important, either to you professionally, or you can sort of respond, because it's all confidential, respond as what you think the folks in your jurisdiction would say. Would they say, wow, all are important, but most important is court appearance? Is it public safety, law-abiding behavior, or is it release? In other words, minimizing detention, making it a limited exception. So please take a few moments, select the radio button on the pop-up on your screen, and then hit submit. And in a few moments, Bryan is going to share the results. So we'll give you about 20 seconds that if you had to rank one of the 3 M's, remember the 3 M&Ms, as primary, which one would you pick? All right, 5 seconds. All right, and Bryan, please share the results. There we go. All right. So we see about 8% of you said maximize court appearance is our primary consideration. 62%, so almost 2/3 said public safety, law abiding is what we would put first. And then in the middle, around 30%, we said pretrial release. All right, thank you. You can go ahead and close that. I can tell you I've done this poll now well over a dozen times, and every single time that same pattern of result emerges. Public safety is usually the overwhelming first choice, release is second, and then you have just a little small distant third place is court appearance. So you all are not unlike in Virginia, everybody else in our country. So here's the implication of that. For, I think, going forward in Virginia would be those of you in Virginia, you and your colleagues who would be necessary, like we talked about earlier, collaboratively to affect the kind of change you're looking for. Do they have the willingness to collaboratively correct any misalignment between the priorities, for example, like that you all just discussed, and the practices? Specifically, if you use a lot of money bail, as Tim has talked about, I think it's fair to say that you have quite a bit of misalignment between your stated priorities, we just did in that poll, and the practice of using money bail. Because what do we know about money bail in Virginia? Well, if you fail to appear, the court could hold the person liable and order a forfeiture, whether it's the person or a commercial surety, what have you. But that's only for missed court appearance, which you saw only 8% of the people said that's the most important thing to us. But if you set a lot of money bail, you're leaving completely unaddressed the issue of public safety, because somebody could be released today in the state of Virginia, this is my understanding of your laws, and go out tonight and murder 10 busfuls of nuns, and they're not going to forfeit a single penny of that money that they posted. So money does not motivate people to comply with the law, nor can they forfeit it. And that's true whether they post cash, deposit to the court property, or a commercial bail bondsman. No one loses money for a breach of public safety. And then, of course, Tim talked extensively about the issue of release, which you said is the most, your second place priority, how money very often interferes with pretrial release, even for people who seem releasable and manageable during pretrial release. So the implication is, my guess is, if you looked at it and thought about it and talked about it in your collaborative efforts going forward, you will see a misalignment between your priorities and current practice. All right, so for the remainder of what we're going to do today is I'm going to use a interactive trivia format. That poll was just to be a little bit interesting as well as a warm-up. Thank you for those of you who replied. I encourage you, as many of you, to reply as possible. Again, we can't see who replies and what your answers are. It's all anonymous. And I picked, there's probably about 15 to 20, maybe data or research-based facts that is very helpful to know as you go forth to improve your statewide pretrial system, or even doing it at the local level. I picked what I thought would be perhaps the most 5 interesting or informative ones because of our time limits today. This could probably be a multi-week long interactive seminar or course. But in the interest of time, what I'll do is the format's pretty straightforward. It's mostly the same for each item. I'll flash up a question. I'll give you some time to read it. And then Brian, I'll let you know when to launch the poll. So folks could submit their answer. They're all multiple choice. And we'll give you time to think about it, submit your answer, and then we'll see how everybody answered collectively. And then after that, we'll talk about why some of the answers are correct and why some of them are incorrect and the implications of those. So let's go ahead and dive right in to the first one. So actuarial assessment tools. That's things like the VPRA or the PSA, Public Safety Assessment. So which of these 4 following multiple choice statements are false? Only one of them is false. The other 3 are true. So I'm going to give you an opportunity to read through those. Brian, let's give them about another 15 seconds to read it on the larger screen here. All right, go ahead and launch the poll, please. So here's the same content you just saw on the slide. It's just in our Zoom poll here. Please go ahead and indicate your best guess as to which of the following 4 statements are false. We'll give you about 10 more seconds. Remember, there's no harm in guessing. You have a 25% chance of being correct, knowing nothing about pretrial. There's no penalties for incorrect answers. All right, 5 seconds. Last call. All right, Brian, how did people respond? Okay, there we go. So which statement is false? All right, so it looks like it pretty much goes in descending order to A, B, C, D. The exact tie with the last 2. Okay, I can remember that. Go ahead and close that, Brian, and we'll talk about it from the slide here. Thank you. All right, so which of these 4 statements is false? The correct answer is B, which was, I think, came in 2nd place. So let's talk about that for a second. Actually, let's address the first one there. A, there is actually no study done by researchers or practitioners such as yourselves that have found using data that assessment tools that are actuarial, like the VPRA or PSA, made racial or ethnic or gender disparity worse in practice. Now that's probably a whole day-long discussion and information we can share. I know a lot has been talked about, but all of the claims that these tools make things worse, right? They magnify racial bias and disparity in our justice system. We know that's a super important issue, and our society and the justice system are struggling with those kinds of issues. But there's no study that shows by using an actuarial tool, you actually make those issues any worse. If anything, we have a little bit of evidence, not a lot, that says we can actually help with some of those issues. So in my words, what I use in my professional work is I say that that's a very important issue. Obviously, we have to pay attention to it, as we all should. But to say that it magnifies or makes things worse in practice for how people are actually treated in terms of release and detention, release conditions, those sorts of things, at this time, that is an unsubstantiated claim. It goes beyond what the research says. All right, let's talk about actually C and D, why those statements are true. By and large, about 8 out of 10 accused people when released pretrial will do what we want them to do. They'll show up to court, not have FTAs, they don't flee, and they're not arrested for a new offense, felony, misdemeanor, violent, or non-violent, about 8 out of 10. That does vary jurisdiction to jurisdiction, state to state. Part of that variation will come with how we measure things. Some of it's based on how we process people, and others based on the defendants or accused people themselves. But by and large, it's about 80%. In fact, the study you have in Virginia, I'll show it in a little bit, that was released just a couple months ago. I was not surprised that your numbers came in right around 80%. Specifically, your court appearance rate from the study that was done, just published a few weeks ago, or a few months ago, was 86% of people made their court appearances, were not issued a warrant for an FTA. And again, close to 80%, 76% remained arrest-free. That's for felony or misdemeanor. So you all in Virginia are very similar to a lot of other places across the country for several decades. And that is people by and large just don't mess up on pretrial release. Some do, but most of them do not. And of course, the advantage to an actuarial tool is it helps us identify who's more likely to miss court or be arrested again before they're released, and gives us the opportunity to intervene. If we don't assess them prior to release, we lose that opportunity. And then finally, D, that actually only about 3 out of 100 people released pretrial, and again, this is kind of a rough average nationally, are arrested again for a new violent offense during pretrial release. So violent behavior does allegedly occur, or alleged violent behavior occurs during pretrial release, but it's very, very infrequent, around only about 3% of the time, which means out of every 100 people released, about 97 of them are not arrested for a new violent offense. And that includes people who are originally charged with a violent offense. Now, you have this data in Virginia. It's nice to know national, but it's really nice to know your own data. And your data actually came in, again, on that state report at exactly this same statistic. You all had an arrest-free rate of 97%. Only 3% were arrested for a violent offense. That is wonderful, wonderful news for public safety in releasing people pre-trial. And remember, that's only being arrested for a violent offense. As we'll talk about in a little bit, a large portion of those people won't even be convicted for it. That's just the act of being arrested. So these tools can actually make people look slightly riskier, if you will, than they actually are, because we're predicting arrest, not actually predicting the conviction for those arrests. And then finally, the reason that B is the correct answer, it's false, is as Tim has described in the past few hours, these tools are most useful for helping decide release conditions, not who should be released or detained, because they don't measure the things that courts can legally detain people for, which tend to be flight and dangerousness. So just the implications of this research here. I know we're covering a lot really fast. Like I said, maybe we'll be able to engage in the future in much more in depth. And you say, well, what study is that? Or I want to read more. Great questions, and we can have that for you in the future. It is important to locally validate your tool and adjust for disparities. So in a nutshell, all assessments we do, whether we're using an actuarial tool like the VPRE or the PSA, or we're just kind of reading a piece of paper that has the person's charges, criminal history, and we're using our experience and knowledge gained over the years to assess somebody's, how likely they are to succeed or fail pretrial, that will always be biased simply because as long as there is bias in the way we conduct our justice system, these tools and our assessments will reflect that bias. And as soon as you eliminate one form of bias, some of them are mutually exclusive, we might have magnified another. But the important thing is we have some very bright statisticians and researchers out there. You have one who helped you years ago with your VPRE. Marie is among the best. They know how to test these tools to mitigate the possibility of those kinds of disparities and build the tool so that it doesn't exacerbate them in practice. It's important to only use the actuarial tool for appropriate purposes. Tim covered that, so I won't talk about it today. But in a nutshell, these tools are very helpful for informing which conditions of release to impose on people after we've decided to release or bail them. It's not to justify to detain them. And part of that is, it goes back to that statistic we saw on the last slide. When 8 out of 10 people succeed, it's kind of hard to justify detaining people when they score on the tool, or put differently, and I don't have this on my slides, but if you look at that Virginia report, you will see that people who get the highest scores on the PSA, for example, from the state of Virginia, are still succeeding right around half the time. No new arrests, no FTAs. So put differently, the question becomes, does it make sense to say, well, let's take all the people who score really high on the PSA, like say they get 6 out of 6 points on that scale, and we're going to detain those people because they're most likely to fail. Well, that's true, they're most likely to fail, but they're still only about 50% likely to fail. So we would actually have to detain 100 people just to prevent 50 arrests. And that's arrests for anything, not just violent crime. Or put differently, you could say we would have to detain 100 people just to prevent 3 arrests for a violent offense. And the thing is, we don't know which of those 100 people, when we release them, are going to be the 3 who get arrested for the violent offense, because they all look the same. So that's just the nature of prediction. Tim covered it. Our laws in America are written so that we naturally are supposed to take those risks in the interest of liberty and respond accordingly when we can. And then finally, as we talked about, most people succeed on pretrial release. And when they're arrested again, as we saw on the last slide, it's almost always for a nonviolent offense. Could be misdemeanor, could be felony, but it's almost always nonviolent, about 97% of the time. So I mentioned this, this data, this research, because it's very helpful when you sit down and you start talking about your detention eligibility nets and your further limiting process, is you can use the research to inform those conversations. All right, let's move on to question 2, effective release conditions. This is a very popular and sought after topic. So which of the following release conditions below, or interventions that we might do with released people, has research shown to improve court appearance? In other words, it gets people back to court. So look at the choices there. I've got A through E. F is a catch-all, all of the above, and then I threw in a G and H as well to make you think a little more hard today. At the end of your Monday, some combinations. So Brian, let's give him a little bit of time to think about that question. Here it is. Brian has jumped up the poll for us, and please make your best guess. I'll give you about 10 seconds. Make your best guess, please. All right, what are our results, Brian? All right, we have our most popular responses were court date notifications, and then more popular was the last one, which said, well, it's court date notifications and pretrial supervision or check-ins, with a few other responses scattered in. All right, we can close that poll. Thank you, Brian. And the correct answer is, our majority got this one correct. All right, nice job. So A and B only, as research has shown, which of the following options here that we often employ to try to get people back to court has there research support for? It's court date notifications, right? And that can be text messages, phone calls, by a live caller or a robocall. It can be emails. There's places using apps. It could be letters, postcards. So lots of modalities, and even the message matters. There's been some research on that, particularly out of University of Nebraska a number of years ago, that actually what we say in the message can actually get us better outcomes. So it's definitely research that every jurisdiction should know when trying to implement this practice. And pretrial supervision check-ins, we have about 4 studies that over the years. It's not a lot, but it's better than nothing, that show that when people periodically check in with a pretrial services staff person, or maybe it's even a court clerk, but there's some kind of active engagement between the accused person on release and someone from the court or the government, just kind of checking in, keeping tabs on them. not in the sense of surveillance or supervision like you might get a little bit more on the probation convicted side, but it's more around providing services and support, reminding them of their court date. It's always a big part of the check-ins, and linking them to services or supports in the community, be it for behavioral health or housing or childcare, education, jobs. That tends to get people to appear in court. Drug and alcohol testing, electronic position monitoring have no or very sporadic support. The overwhelming majority of the research shows that those things do not improve court appearance. And then money bail. Also, there's been a few studies out there, but they're pretty dated and they have some issues methodologically with those studies. And in some, that posting money, although it seems to make common sense, and it's been around, as Tim described, for well over 100 years now, that money bail does not motivate people to come to court. And so keep in mind, I think it's very important, actually, what Tim said, and actually I remember the day that Tim and I, we were in Utah talking to your colleagues, maybe about 5-6 years ago, when we realized that the best way to evaluate if a release condition is effective, which everyone wants to know and say, hey, is this effective? Is that effective? Is to hold it up to the 3 M's all at the same time. Let's take court date notifications. That's a fun one, actually. So we say, does it improve court appearance, right? One of the 3 M's to maximize court appearance, one of our goals. The answer is, yeah, we got a good number of studies to show that we can get some pretty good results compared to not reminding people. Okay, it passes that one. What about public safety? Does giving court date notifications keep people out of trouble with the law? Well, no one's actually ever tried to answer that yet, or even tried it for that purpose. So I would say big question mark for that one. Although theoretically, if I had to guess, would not be surprised if it does not impact law-abiding behavior. And then thirdly, does court date notifications affect release and detention? No, it doesn't, because once people getting out of jail is not contingent upon them getting notifications, right? They get them after the release. In contrast, money bail, here's where that one often fails the test of the 3 M's. We could say, well, does money bail improve court appearance? You have a few studies that might show it does, but they have some research problems. We have other studies that showing it doesn't. So kind of a big question mark there. What's it do for public safety? I've seen 2 studies ask that question and say, does posting money decrease pretrial arrests? And the answer is no, it doesn't. It had no effect. But that kind of makes sense, because if you can't forfeit the money, why would it motivate you to follow the law? So it's got legal and research support to say it's not even really relevant. And then, of course, it really fails the test around the 3rd M, maximizing release, because we know money bail causes people to stay in jail, whether a judge wanted that to be intentional or not. So I would suggest going forward, whenever you have an idea or are evaluating research or study to try to answer the question, is a certain release condition, it can be monetary, non-monetary, what have you, is it effective? You need to define what you mean by effective, and I would suggest holding it up to the 3 M's, which would be relevant for the state of Virginia. All right, so here's the implication of that one. For you all going forward to Virginia, do folks in Virginia have the willingness to collaboratively cease, for the most part, using release conditions that do not achieve the purpose of court appearance for which they're set? In other words, if we're using money to try to motivate people, but it doesn't motivate people, as Tim alluded to earlier, it raises question about the rationality of that practice. And we could say that even for non-monetary practices, such as GPS or drug testing. But I think this is an important question to consider as you all are consider reimagining bail in Virginia going forward. All right, let's go to question 3, effective release conditions. Same exact question, most of the same choices, but this time for having people remaining law-abiding, arrest-free during pretrial release. So which of the following conditions has research shown to improve people remaining arrest-free? So now we're talking about, right, that other M of maximizing law abiding and public safety. Brian, go ahead and launch. Please select your best guess. Give you about 15 seconds. All right, Brian, what are the results? All right, which of the following? Overwhelming choice was pretrial supervision and check-ins, 57%. And then second place was actually, we don't think any of these things improves law-abiding behavior according to the research. And we have a few other choices thrown in. All right, we can go ahead and close that poll. Thank you. And the answer is actually, our second group got it, actually none of the above. There have been a number of studies that have looked at, does pretrial supervision, having people check in, improve court appearance or people's law-abiding behavior. And those studies have shown that for the most part, it does help with court appearance, but they saw no effect for reducing pretrial arrests. And that effect for court appearance also tended only to be true for people who score higher on an assessment, something like the VPRA or the PSA. So it's not that pretrial supervision check-ins make sense for everybody. It tends to be only those people who seem to be what in the past we might say have higher risk scores, or they score higher on our assessment. This is one of those things where it always kind of it's that heartbreaking moment when I'm working with jurisdictions when they say, well, what can we do to get people to abide by the law on pretrial release? It's super important. In fact, from your poll earlier, you all have said it's the most important thing. And at this, all I can say is at time, we don't have a lot of studies. We definitely need more. But overall, pretrial supervision has not gotten, again, globally, people to abide by the law more than not supervising them. But of course, then we also, and it's say, well, gosh, what are we supposed to do? It's like, well, court date notifications, we haven't even tried that. Drug or alcohol testing, the research shown that doesn't help. Electronic position monitoring, GPS, that hasn't seemed to help. Money bail, of course, isn't going to help. And so, gosh, what do we do? And I think we definitely need more research out there from both our scholars and our practitioners. But at the same time, remember, about 8 out of 10 people are going to behave themselves anyway. So I think the implication of this, it doesn't mean never do supervision because it doesn't work. We don't have enough studies to say that. It's not like the opposite of an evidence-based practice. It's not a futile practice, if you will. I think the implication just reminds us, this research, is that we should be very careful in using it and not overuse it, given that we've had the compass needle of the studies is pointing to it may not do what we are hoping it would do for law-abiding behavior. So similar implication as before, do the folks in Virginia have the willingness to collaboratively cease, again, for the most part, we're not saying ban it, using release conditions, all the ones we just talked about in that previous slide, that don't improve law-abiding behavior, even though we're setting them for that purpose. So again, there's not a great answer to this question, but it's definitely one that those of you in Virginia should talk about as you get together going forward. All right, question 4 out of 5, system change outcomes. So we've had about 7 studies now that show which pattern of results for the 3 M's, here's those 3 M's again, after those jurisdictions began using, they moved away from secured money bail and implemented other improvements. Maybe they implemented an assessment tool like the PSA. They started to have defense attorneys appearing at first appearance. The first time a defendant sees a magistrate or a judge, they're represented by counsel, so 6th Amendment kinds of things. They may have started a pretrial services program from scratch, started doing some monitoring, supervision, those sorts of things. So they often come, those kinds of improvements comes in a package. So, and it's different everywhere. But what's fascinating is even though these jurisdictions implement their package of improvements differently, they tend to find the same pattern of results. So look at A through D there. Let's give them a minute there, Brian, to read them on the big slide. This one's takes a little longer. All the studies showed which pattern of results for the 3 M's. And when I say maintained here on the slide, I mean like the rate remained about the same. They were releasing about the same amount of people. That's what maintained means here when it's used. All right, Brian, go ahead and put up the poll. Please make your best guess. Okay, last call. And what are the results, Brian? All right. So it looks like the 2 most common answers are that everything increased, which was choice B, or choice C, we got more people out of jail, but our appearance and law-abiding rates stayed about the same as what they were before when we used lots more secured money bail, whether that's cash or court deposits or going through bondsmen. All right, go ahead and close that out, please. And the correct answer is C. We wish it was B, where gosh, we got more people out of jail, more people came to court, more people stayed out of trouble, but we're just not tending to see that pattern of results now across 7 studies, and these studies go back several years now, at least 5-6 years, most of them. What we're finding is when jurisdictions stop using secured money bail, either by a little bit, medium, or a lot, they tend to get a lot more people out of jail. Well, no surprise there. Secured money bail causes detention. So when we're using more recognizance or supervised release, more people are released. So we start to maximize that M, if you will, maximize release. And so that raises the question, well, we have more people out, that's much more opportunity for failure. That's true. More people could now not show up for court, or they could be arrested again, right, for an offense committed allegedly in the community. But we're just not seeing that. And I think part of the reason is jurisdictions have gotten very wise because they're not willy-nilly and careless about who they're releasing. They're increasing releases, but they're not just releasing everybody, right? They're being very careful. And one of the ways they're being careful is they're looking at things like Tim described, is they're looking at their detention nets and having further processes in place for due process and making sure, remember his one slide, I think it was his second M&M slide where he talked about getting the right people in the right place kind of thing, maximizing appropriate placement. They seem to be doing a pretty good job at that. Your colleagues who have been there and done this, the kinds of things you're thinking about in Virginia. So they're getting more people out of jail, of course, which is great news for taxpayers, as well as just getting those people back into their communities where they have to be responsible and law-abiding and take care of their families and work and pay taxes. And we're not seeing significant or statistically significant increases in failures to appear or in arrests. They're staying about the same. So that's it fascinates me that even jurisdictions that implement different practices, the new policies, they're all a little bit different from each other. They're finding the same overall pattern when they move away from secured money and also couple that with some other improvements. So here's a slide that kind of summarizes what those studies were or where they occurred. Jefferson County, Colorado, it was back in 2014. That's actually where Tim and I met and did a study there before we started working more nationally. Yakima County, Washington, right? It's a smaller rural county. Maybe Brian, that goes to the question we received earlier. Can rural counties benefit from this? The answer is yes. And Yakima is a good case in point. Philadelphia, Cook County, where Chicago is, Mecklenburg County, Charlotte, North Carolina, state of New Jersey, and New York City. On this slide, what you see in those 7 jurisdictions are jurisdictions that said, this is how we used to do business. We moved away from secured money bail, and now we do that new business. How have things changed? How have the 3 M's changed? All of these studies looked at the 3 M's. There are other studies in other jurisdictions out there, but I don't include them because for me, They had less rigorous research. They did not look at all three M's at the same time. Now, New York City is a little different because if you're familiar with New York law, they actually don't look at public safety and law-abiding behavior on pretrial release. For them, the process of bail is only about court appearance. There's only a few states like that. But they were so thorough on looking at both the effect on jail and release as well as court appearance that I included in here. I also included in the other columns, just it's kind of like an FYI, did these jurisdictions use an actuarial tool? The Jefferson County study did not, and neither did Philadelphia. They released more people. It's kind of studied when more or less people were released based on the use of money bail, but they didn't use an actuarial tool as part of their overall study or system improvement effort. And then because Virginia was looking at the PSA and he's used that in your state report recently, I included here the last column that some of these studies actually used the PSA as part of their system improvement efforts. New York City has their own custom built tool for that jurisdiction. They don't use the PSA. So again, fascinating to me that all of these studies, when researched well, show that you can increase people getting out of jail at no harm to the integrity of the court in appearance and at no harm to public safety. Great, again, great news for public safety and a way to balance those three M's. All right, fifth and final question. Case dispositions. So the 2021 study I've been referencing for a few minutes now, that looked at a cohort of defendants released or brought into court, I should say, or charged in October of 2017. So here's a neat question. So it's kind of some local data for you. What percentage of those defendants, accused people, arrested basically in October of 17, were convicted of the offense they were arrested for? So that's their original case. So they were brought into the introduced to the justice system in October 2017. They're arrested for an offense. What percentage of those people were eventually convicted of that offense? Approximately how much? All right, go ahead and make your best guess, please. You have 1 in 5 chance. If you haven't read the report yet, I highly recommend it. It's one of the best I've seen in terms of just tracking relevant and important data for pretrial policy making. It's really good. And what's the results? All right, great. So you see the most popular answers right around the high 30% was, hey, about 35% we think, about a third get convicted, and the others about 6 in 10 got convicted. And we see other responses. No one guessed 97% conviction rate. All right, good, because I can tell you that's not the correct answer. All right, go ahead and close that poll. The correct answer is 59%. So about 6 in 10 people were eventually convicted for the offense they were arrested on. The reason I chose this statistic, and there's many good stats in that report, is this. Here's for me what the implication of that research shows. Are you and your colleagues in Virginia willing to discuss the utility of detaining accused people pretrial, just not letting them go outright, or second, ordering multiple or onerous release conditions like GPS, drug testing, even frequent check-ins, when approximately 4 out of 10 people will not even be convicted of the offense for which they were charged? You could ask that question, say, well, what would it take? What if 6 out of 10 aren't convicted? What if 1 out of 10 aren't convicted? Or 90% are convicted? But this is the data you got. That's how the system in Virginia works. This is how people are processed through your system. So you can see when we assess someone, whether it's with the VPRA, the PSA, or any other actuarial assessment, the best outcome we have is if they're arrested again. But remember, of 100 of those people who are arrested, only about 59 of them are actually going to be convicted of that arrest. So people can look really risky or more concerning on a tool, or when you read their arrest report, right, from the arresting officer, for example, looking at their criminal history, but realize that 4 in 10 of them aren't even going to be convicted. So again, I just say that because it's another important dynamic to keep in mind as it's shaping your new policies, your practices, or any revisions to your statutes that you might make. In fact, I also looked, but I don't have a slide, a little bonus statistic I pulled out of your state report, again, because I'm a big fan. When people are arrested on pretrial release for an alleged new offense, about what percentage of the time are they actually convicted for that arrest? The answer is it's about 46, 50%. So about half, a little less half the time. So even when people are arrested during pretrial release, only about half the time will they actually even be convicted of it. So again, that helps us put into the context why I think that's useful, is I think it's important for all of us to think about, okay, they get arrested. First, not many people get arrested, but when they do, only about half the time they're ever going to be convicted for it. So how much weight in our mind should we be thinking about how likely people are to get arrested if only about half of them are even going to get convicted for it? And we saw that when they are arrested for those offenses, it's also in your state report, that about when it's a felony arrest, about 60% of the time it's drugs or theft. So even if you say, well, we care more about felonies and misdemeanors, I've heard that many times. Okay, fair point. But 6 out of 10 of those felony arrests tend to be for theft and drugs, right? It's not violent behavior, it's not assaults, it's not murder, rape, robbery, those kinds of things. I mean, they happen, but it's very, very small percentage of the time. So much that I think it raises this balancing question that Tim raised earlier, that we're talking about restricting or taking away people's liberty. When most people succeed, and when they do fail, it tends to be for relatively minor things. And that's true for even misdemeanor arrests. I think the most common misdemeanor arrests during pretrial were contempt and driver's license. Again, the two most common ones by an overwhelming majority. So I think you can use your own state data to shape and inform your conversations going forward. Well, that's my last slide. As I mentioned, I love talking about this research stuff. I could do it all day, but we don't have all day. I picked what I thought was the 5 most interesting or informative or useful starting points. You can get much more information on what research says, like through our research summaries at the APPR website. If you have any questions, here's my contact info. Please feel free to give me an email. If I don't know the answer, I'm happy to connect you with someone who does. And that is all I got. And Brian, I'm turning it back to you for our last 10 minutes.
Michael, thank you so much. We have a few questions. So one really important one post-COVID is you mentioned that for people who score high on risk assessments, there seems to be value in terms of court appearance rates for pretrial supervision. Is there any data yet, any studies, any research into whether that needs to be face-to-face or virtual or phone, and how things have changed during the pandemic, or how that would work?
So the answer is not published, nor am I aware of unpublished. But the pandemic, its effects is very recent. You know, there's always a lag, right, between societal events and researching their effects. So I think that'd be a great study. That's something you all could do in Virginia, right? You may be able to go back into your data. You might have some pre and post. I know of some pretrial services agencies that have said, because of COVID, we completely stopped all of our face-to-face visits. It's all done through telephone, some video conferencing, or I don't know, whatever they FaceTime, Snapchat, whatever they do. And several of them have said, it's been so successful, we're not going back. Why make people take off work, find childcare to come to an office during the day when they have jobs too, to meet with us when we can accomplish the same thing, get the same results online, you know. But I would say, you know, that's an impression, it's an anecdote to be determined. All I can say is those studies I referenced earlier, some of them did have a combination of face-to-face and telephone check-ins, but not enough to parse out, is one modality superior to the other? And it could be like other things in life. certain modalities work better for certain people, could be subpopulations or individuals. I've personally been a fan of some of my pretrial services colleagues when they say, all right, if defendants have to check in, maybe it's once a month or something like that, we talk about what works best for them as an individual and try to accommodate, their schedule versus just saying, no, you got to come down to the office, do face-to-face. And if you don't, we send a letter to the judge and those sorts of things. So I'm a big fan of individualizing and customizing the modality of the check-ins as well as the frequency and involving the client in that decision-making.
Great. And a couple of quick hit. When you were saying the 59% of people are not convicted of the crime they are charged with, that means the charge is written. So some of those people are acquitted, some of those people, the charge was null prost, and some are convicted of something other than what they were charged with initially.
It could be, I understand that why that question is phrased that way. I could have overstated that they weren't charged of that offense. It could be that they just weren't convicted, period. I would have to go back into the report and in fact, that would be, I don't have the page number. Let's see. Yeah, sorry, I don't remember what page number it was in the report, but I'm sure you're some other folks, once you look up that report, you'll see it. It may be that they weren't convicted, period. That's my recollection, but I'm not sure about that.
And another quick hit one is that 60%-ish statistic, is that the same nationally? Is there any research on that or to state by state dependent?
My guess is that's not only going to be state dependent, it's probably local dependent just because of different court processing, prosecutorial, and arrest practices. I have not seen national data on that. I think just before you this summer, the state of California came out with some similar data. And I'm not sure, but my recollection was their conviction rate was even a little less than the 60%. And again, that could just be how processes or how cases are processed in those jurisdictions.
Great. I think that's all the questions we have, and we're coming up on time. Tim, feel free to come back on. Thank you so much, Michael. That was great information. Tim as well. A couple things to remind anyone, especially the Virginia people here. Michael referenced the pretrial data report that came out from the Virginia State Crime Commission, but just 2 years ago or last year now, I can't keep track of all the legislative sessions. We're actually going to be tracking a lot more data and making that publicly available in Virginia. That's going to be available through the Virginia Sentencing Commission's website. They're going to have a public portal. I think hopefully launching by the end of the year, I think is the date on that, if not next year, that's going to be updating that information. And I think searchable by county and lots of other things. So we're going to have a lot more information to use both statewide and locality specific to look at the health of our pretrial systems and look at what's going on in our pretrial systems, and it's publicly available. So that's going to be available to policymakers as well as stakeholders to try to look at our systems and see how we're doing locality to locality. Also a reminder that things on statewide are hard. They're always hard, but localities can change too. There's lots of things going on in lots of localities, both urban and rural, with lots of different political environments, lots of different resources around the state already, where people are doing really great things and have been for years because of advocacy on a local level, both inside and outside the system, applying that pressure Tim was talking about inside the system locally as well as on a statewide basis. So hopefully everyone will take some of these ideas and try to use that either within your own agency, if you're a pretrial services officer, defenders, we need to be better, Commonwealth attorneys, or local stakeholders and judges and everyone else as well. Thank you so much to VCCJA for facilitating this. Everyone's contact info is up on the screen. Everyone at VCCJA deserves a shout out, but certainly Smith, Steve Austin, Wes, everybody making this happen today and run very smoothly. Thank you again, Michael. Thank you, Tim. Hopefully we will reach out to you all in the future. And with that, thank you all for joining us and sticking with it. Hopefully you learned something, and everybody take care. Have a good day.
See you guys.